Will everybody come to order? I'd like to welcome everybody to this special meeting of the Board of County Commissioners. I also ask that if you have any cell phones or other electronic devices to mute them or turn them off at this time. Will, Ms. Sarah, would you lead us in the invocation and the pledge?
Dear Heavenly Father, we thank you for the opportunity to be here today and represent the great people of Walton County. We thank you for such beautiful weather, and we also thank you that we have not had rain in 3 days. We ask that you guide all of us here and give us the strength and the wisdom to do what is right, do what is fair, do what is honest for the people of Walton County. And all these things we ask in thy name. Amen. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All the way in the back. Thank you. Okay, as we move forward today, we want to make sure that we have a good, clean record of this process. So we're going to ask everybody to be recognized prior to making any type of statement, so the reporter will have a good, clean copy of everything that took place today. Mr. Davis.
Thank you, Mr. Chairman. First of all, anyone who anticipates testifying or speaking before the board today, would you please stand, and we're going to swear you all at one time. Just raise your right hand. Dana, your witnesses and your folks. Okay. Is that everyone? Do each of you solemnly swear or affirm the testimony you would give before this board today will be the truth? I do. Thank you. If you would, when you come to the podium, make sure you say your name and if you're an attorney, who you represent, so we can assist the court reporter. Also, I will stop you if there's two people talking at one time, because frankly, she's good, but she can't take down two people talking at one time. Commissioners, have any of you had any ex parte communications regarding the substance of today's hearing?
No.
Oh, thank you. We have a published schedule. I think each of you should have a copy of it. We will abide by the published schedule. So if you're an attorney or if you're a party or somebody going to speak, please note those times, because we are going to stick to it. I'm a good Presbyterian, and we got to have a order of worship, and we have an order of worship, and we're going to follow it today. Okay, so I've instructed the chairman to bang the gavel when it's time, and we're going to do that. Any objections, I reserve the right to advise the chairman on, and I would like to keep the arguments on the objections to a minimal amount of time, because obviously we're limited in the amount of time we have today. So with that, I think, Mr. Chairman, the first order of business would be the staff to present to the commission on its compliance report.
Okay.
Hang on just a second.
Just two housekeeping that I talked to Mr. Davis about. I wanted to...
Dana, say your name.
Dana Matthews for Sandestin Investments. Two things that we discussed was that there is a memorandum that Mr. Davis issued May 22nd, 2014 to all the lawyers involved as to what the procedure would be today, as well as the agenda, and it was my understanding that that was going to be approved by the board before we got started. That's number one. The second thing is that there was a request by Mr. Davis that we stipulate to staff's exhibits, and that we discussed them stipulating to ours, and we've agreed to that with lawyers, and I wanted to get that on the record. And we have two exhibit notebooks. They're called Exhibit Notebooks 1 and 2 with various tabs, dated today's date, under Sandestin Investments. A copy for staff, which will go to the court reporter or the clerk at the end of the day.
Thank you, Mr. Matthews, and you're right. We do need, first of all, assuming there's no objections from any other party, we're going to admit the county's exhibits and the applicant, for lack of a better word, the developer's exhibits without any objections. Are there any objections to either of those? Mr. Heath says none, and Mr. Vorbeck says...
No, Mark, the question is
And does anybody have any objections to the exhibits that they've proposed at this point? They being Mr. Heath and Mr. Mr. Vorbeck. Hang on a second.
The only exhibit that I know that I've gotten a copy of would be Wendy Gray's report that Mr. Vorbeck wanted to introduce into evidence. I've already laid out my objections in writing on relevancy, so subject to the chairman, abstaining or on that issue, that's the only thing I have. Okay. I don't know what Mr. Heath is bringing as exhibit.
Why don't it then at this point, Mr. Heath?
Thank you, Mr. Davis. I do have a number of exhibits. They have been circulated via email. They are expert reports, and these are things that have been in the public record and to the public knowledge of a lot of people. And I have them in binders. They're already numbered, and they will be entered at the end of our presentation.
Just to keep a clean record, make sure Mr. Matthews has them, and then sometime before lunch we'll see if we can get them admitted.
I will give them to them. I have copies for everyone.
Thank you. Mr. Vorbeck.
Thank you. My name is Gary Vorbeck, for the record. I have no problem stipulating to Mr. Matthews' exhibits as long as they're stipulated too. And the county, everybody in the world's had it. We handed our report in 10 days ago, and everybody purposely, so nobody can say they were blindsided and had a copy of our report. So it's been available to everyone.
So if I'm hearing everybody correctly, the staff's exhibits, the declarant's exhibits, Mr. Vorbeck's exhibits will go ahead and go in without objection, and we'll deal with Mr. Heath's exhibits hopefully before lunch.
Again, I
subject
know they're going to come in, but subject to the written objections and the oral objections that I've made for the record.
And Mr. Chairman, what I would suggest then is you admit them to evidence. Thank you. Next, one other thing. We have published a order of worship today. I need the commission, if you would, to make a motion in a second. That is the procedure we'll follow today.
Got a motion and a second. All in favor say aye. Aye. Motion carries.
Thank you. Now, Mr. Stewart, I'm sorry, I got ahead of myself.
Greg Stewart of the law firm Neighbors, Giblin Nickerson, representing staff. One just follow-up point on the exhibits. Just so the record is clear, we are introducing the staff report, Exhibit 1, which Ms. Bradley is the author of. She will be available for technical questions concerning that. I'm going to make a few comments to kind of walk through the issues. In addition to Exhibit 1, there are sub-exhibits, Exhibit A through Exhibit EE, which we have provided to all the parties. We've also submitted an exhibit list as part of the record. I would ask that the other parties also submit an exhibit list so we know exactly what is in the record. Okay. Thank you, Mr. Chairman, members of the Commission. Before you today is a compliance hearing. It's a hearing to determine whether, in fact, the Sandestin Development of Regional Impact is in substantial compliance with its development orders. And the standard that is to be applied under the statute, the responsibility that is given to the county is that they are the first line in determining whether, in fact, a development is in substantial compliance. And this is the excerpt from the statute, provision of the DRI statute. I'm going to talk a little bit about the process that county staff underwent to analyze the development, a little bit about the determinations that we made, and then a basis for that determination. Next, please. Now, the initial annual report was the 2011 annual report, which was submitted in 2012. And staff began looking at this report, and it was difficult because the format of the report had changed over what had been submitted by prior developers. And so staff was having to try to recreate and make sure that we were analyzing apples to apples, oranges to oranges. Staff was nearly done with that report when the 2012 annual report was submitted in 2013. That again varied in the format, and there was a reconciliation process that staff had to go through. It was very tedious, very painstaking. Next, please. Now, in addition, the developer, to assist the county staff, attempted to go and do a parcel by parcel ground truthing. and submitted various charts which would show exactly what they were claiming in the different land use categories. And this was very beneficial to staff because for the first time in Sandestin, we had a determination as to exactly where these open space and other issues, property classifications were located. Finally, on April 21st and again on April 24th of this year, additional submissions were made seeking to include more open space categories, 65.1 acres that had never been claimed before. Staff went through that, analyzed that, and the report that is before you today is based upon these analyses. Now, the first thing that's important is to understand what is the baseline. What are you actually looking at to determine whether a development is in substantial compliance? And in this particular case, next please, it goes back to 1984. And in 1984, Sandestin submitted a notice of proposed change, an NOPC. And county approved that NOPC. But the Department of Community Affairs rejected it. And ultimately, a settlement agreement was entered into between the developer and DCA to set the baseline for future analysis of Sandestin. And part of the agreement was to accept the NOPC designations for the different land use categories and supplement it based upon additional material. And then that occurred in 1985. And what we ended up with in that report, in that agreement, was the initial submission sought to have 954.8 acres of open space at Sandestin. As supplemented by the developer themselves, that was raised to 1,031.1 acres. Next, please. Now, initially in our discussions with Sandestin, they indicated that they felt the initial number, the 954.8 number, should apply. However, the agreement itself, and this language is taken from the agreement, makes it crystal clear that when they supplemented that set the baseline for exactly what they are required to maintain at Sandestin. Now, next please. We also, just to clarify and make sure we were on the right page, we asked DEO, Department of Economic Opportunity. And this is an excerpt from an email from Anna Richmond with DEO on this issue. They confirmed that the 84, as supplemented by the 85 agreement material, is the baseline by which all changes are to be evaluated. Next, please. Now, after reviewing all of the material and the individual plat, parcel by parcel basis, staff has come to the conclusion that Sandestin is not in substantial compliance with its development order for the following reasons. There has been a significant decrease in the amount of open space at the Sandestin DRI. There has also been a substantial increase of commercial land use entitlement beyond what was authorized. There's been an increase in residential property, which has not been justified or determined, and there has been an increase and decrease in two or more categories, which is a criteria under a substantial deviation. Now, next please. One fundamental problem that you're going to hear about throughout the testimony today is changes of land use. The developer has determined that they believe that they have the right to make land use changes through their annual report and not come to this board to seek an NOPC. And that's a fundamental issue because you will see throughout this that they continue to shift and move uses for property and never come back to the board. They never allow the public to have input, and they alter their land uses. Now, each of the 4 items that I mentioned, I'll talk about briefly. Next, please. And the first one is the open space analysis. Next. Now, in reviewing the open space, again, another dispute with the Sandestin in terms of what standard to be applied. In 1984 and 85, the statutory language for a substantial deviation was open space was a variance of 50 acres. Within the next year or two after that, the legislature changed that to reduce it to 20 acres. Sandestin said, well, if you're going to evaluate us, you have to use the 1984 statute. We disagreed. Next. So what we did is we sought counsel of DEO as to what is the standard to be applied. DEO told us it's the 20 acres. It's the current standard that is in the statute that is to apply. Therefore, for a substantial deviation, if there's a variance of 20 acres in open space, that will be deemed a substantial deviation, notwithstanding what the statute read in 1984. Next, please. Now, based on the initial submission by Sandestin, in 1984, they had 1,031.1 acres of open space. In the initial reports, that was increased. It said 1,080.24 acres of open space, which shows a gain of 49.14. Next one. As supplemented by this April supplementation that they did, the 1,031.1 acres, they supplemented that up to 1,139.12 acres, and they are claiming that they have an increase of open space of 108.02. Not bad. It shows there's no deficiency of open space. Their report indicates there isn't a problem. However, when you go and look at how they're coming up with those numbers, what they have done is they have completely changed the rules as to how open space is considered in a variety of different ways. And that open space that existed in 1984, they did not apply those same criteria currently. They made up new criteria, added new areas in. And we'll go through those. Next, please. Now, 4 areas as to how their open space numbers are inaccurate, as we believe. First of all, and each of these I'll discuss briefly, included additional roads, that there were substantial changes to prior approved land uses by the developer. There was the inclusion of inappropriate areas as open space, and the April submission, they included setbacks for open space. Now, let me talk about each of these. Next, please. Next, please. As part of the 1984 settlement with DCA, and again, the county was not a party to this agreement. This is DCA and the developer. But the developer in the supplemental material was allowed to identify its open space. And in the submissions, it had certain open space roads, which were major collector ROW, right-of-way. And they included that as open space. And DCA allowed them to do that. Now, this includes paved roads and right-of-way. Now, whether the county would agree or whether that's a good idea, when staff looked at it, DCA had decided that was the baseline that we have to compare. So we said, fine, we'll look at what DCA did, and we'll evaluate your suggestion of including more roads based upon that criteria. Next, please. Now, this is the map that was showed the roads that were approved by DCA. And some of these roads, like this road here, that was never built. Some of the other ones were never built. But this was basically the analysis that was submitted in the right-of-way, and they were termed major collectors. Next, please. And the total right-of-way as accepted by DCA was 74.4 acres. However, the developer, within those numbers that I showed you before, is now claiming 148.92 acres of roads, and double what DCA had approved. And so the staff underwent a laborious process of analyzing these roads. Next, please. We had 3 independent reviews of the roads. 3 groups went out and looked at every road they were claiming. We utilized the same criteria which DCA had, which were major collector right-of-way. And staff could only support 86.88 acres, applying the same standard as DCA. And again, whether we would have agreed to road as open space, in our view, we had to go with what DCA had committed to. And so we felt, from a staff perspective, that the fairest thing to do was to apply the same criteria that DCA had applied. And we came up with 86.88, not 148.92. Next, please. And these are the roads that staff, in reviewing, felt that they could support. Now, based upon our review of the roads and the ones submitted, it is clear that the developer was seeking to change the standard for roads being considered as open space to increase the amount of open space they had. And all without seeking the approval of the board. And that's fundamental. All of these things are being done unilaterally. The board is not being given a say, and we think that's improper. Next, please. Now, in order to kind of see the difference, and we saw the map in those major collector roads, let's take a look at some examples of what, in fact, they were claiming as right-of-way. Next, please. This is Cove on the Bay, little cul-de-sac. They were claiming 0.5 acres for roads. Next, please. This is the area. You can see it. It's an internal street serving those properties on that street. Next, please. The marina. They claimed this as a major road. Next, please. That's a drop-off point, a minor right-of-way right there. That's not a major collector. That's inconsistent with what DCA and the developer agreed to back in 1984 and 5. Next, please. Bay Pines 1 and 2. See it's another internal street in the aerial, please. You can see that's right there. It's serving those properties on it. It's not a major road. Next, please. Prestwick, again, minor cul-de-sacs serving a small number of areas. An aerial. There. Next, please. Monarch, undeveloped, and this little road here, 0.7 acres. Open up, please. Look, that's one. And this is the road. That's not a major road. That's completely inconsistent with even what DCA had agreed to back in 84, 85. And that is what they wanted. That's how they boosted their open space on the roads. Next, please. Now, the second category of changes in open space was there were substantial changes to prior approved land uses by the developer. Next, please. Now, this is Crystal Lake, Old Town, Crystal Cove. And you can see here that they claim the road. There's a lake. And this is nature preserve. Nothing is to be built in nature preserve. Aerial, please. There's 4 houses built in their nature preserve, and they're still claiming it. Next, please. Another interesting one, Jolie Island. This is their submission. And these particular charts These were all submitted by the developer. Jolie Island has green space area here, 5.3, 6.2 acres for residential. Next, please. Take a look at the aerial, and nothing particularly there. However, if you go back to 1998, next, please, there was a development order amendment. And this is a letter from Tom Beck, Department of Community Affairs, February 23rd, 1998, concerning their proposed development change. And this is the excerpt dealing with Jolie Island. Parcel number 2223, acres for medium-high, high-density residential, 96 dwellings, to athletic, recreational, nature preserve with 0 dwellings. They changed their development order in 1998 to prohibit any dwelling units, but now on their annual reports, they are now claiming that they, in fact, have 6.2 acres for residential development. Again, without bringing this matter to the board, without giving the public an opportunity to provide comments. Next, please. The third category is inclusion of inappropriate land use areas as open space. And what we found, next please, is that they began to increase the open space. They've started including median areas in roadways. They started including common areas in multifamily to push up the numbers for their open space. Next, please. Here's an example, Gran La Sala, I believe, Bahia, and this is a multifamily. And you can see here, that's the footprint of the building. That's the footprint of the building. This is all, this green area here is all treated as open space. Go to the aerial. That open space is a pool and a parking lot. Here's the footprint of the buildings. That's not open space. And that's what they're including as open space to get that number to where it is in the annual reports. Next slide. This is the bungalows. Again, they claim 0.2 acres there for that particular area. And go to the aerial. There's construction, there's improvements in that area that they've claimed. That's not open space. It looks like there's a pool there. Next, please. This is Turnberry Villas. And again, this is and they've got open space here. They basically have included all of the common areas as open space. Common areas of a multifamily. Next, please. And you can see roads, parking, but they've kind of every other inch around the buildings, they've now treated as open space. Open space traditionally were larger, contiguous tracts, not these little common areas, medians. That wasn't the intent of open space. Just because they haven't built up on it doesn't mean it constitutes open space. Next, please. This is the plat, just to show you where that is. And everything else, other than the footprints of the building, is now sought to be treated as open space. Next, please. This is Heron Walk, another interesting one. A residential strip. Got open space there, open space there. Aerial, please. Next. So here's your residential strip. Here's along the marsh or there. Here they are. They have golf cart paths through there. They have paving through here in this area that they're counting as open space. It's a median, basically. Again, that's not what open space was intended to be. Next, please. This is the plat showing footprint. Next, please. The fountain. Right here, that we counted this roadway, the large one, as part of the 86.88 acres road. But they wanted this little interior street also. And then this area here, which is just a little buffer, median. Next, please. So you can see that right there. All that is just a little median between the frontage road here and the main highway. That's not open space. Again, if it was going to be treated as open space, it has to come to you to decide that that is the appropriate way to treat it, not unilaterally by the developer. Next, please. Now, the last category deals with the April submissions that they made. Now, what they were including is basically a 15-foot setback along all golf courses, along all lakes, and they just automatically included that. Next, please. And that's the 65.1 additional acres that were brought in. Now, we looked at these, and again, these came in at the 11th hour, but we looked at these, and our determination is, next please, that first of all, they're not buffers, they're not unimprovement areas, they're just setbacks, which there is a difference. These had never been submitted to you that these would be appropriate for consideration of open space. And frankly, the Architectural Review Board for Sandestin routinely grants variances and allows construction within them. And you'll see in some of these, there is construction within these buffers. Next, please. This is Sandestin Bay Estates parcel. You'll see here, this is particularly interesting. They've treated this as a nature preserve. And then the little strip of green right up is their buffer that they're claiming along here also. Go to the aerial, please. We can't find the nature preserve. We don't know what they're claiming. And you can see here, as far as the buffer goes, there's construction almost right to the property lines. Yet they include those automatically without regard to whether they are a true open space, a true setback where there can be no construction in it. They've just automatically added those to their tower. Next, please. This is the plat. Does not show any dedicated nature preserve area. Next, please. Inspiration, this is a multifamily. Next one. Believe, again, all of these areas here, including that area, are all treated as open space. Next. Okay. Next. Genoa, a median area here, and again, their buffer around the lake. Go ahead. You can see there in this area, there's a lot of building right up to the line in this area, but yet it's included as open space. Next, please. That's the plat. Next, please. Island Green Hill, I believe. Again, this is another showing the buffers all the way around. Go ahead. It's in this area here. Next, please. This is what they're claiming. Okay. Now, basically, after staff's analysis, and we did give them some areas with saying that they are legitimate and could be considered if it was brought back to the board for approval. But we found that where there should have been 1,031.1 acres based on the 1984-5 threshold, there is only 959.52 acres of open space, a decrease of 72.1 acres from what was required to be maintained. That's 180.2 acres less than what they're claiming. Next, please. Now, we also looked at their commercial. And what the developer has done is he has merged all his categories, non-residential categories. Commercial, club, community services, they've all been merged into one pot of entitlements. Where it used to have broken out by categories, now they've been merged. And he has claimed 972 145 square feet of non-residential entitlement. Not designated as commercial or anything else, just entitlements. And so he's eliminated these three categories by merging them all together. Again, you cannot do that unless the board approves it. That is a fundamental change in this DRI. Next, please. Now, additionally, there's a concept of ancillary space, and the developer unilaterally decides that of some of the development he's built, 22,024 square feet of previous commercial are ancillary. And therefore, they don't count against his square footage pot of entitlement. Ancillary space traditionally is that if you have a building, a commercial building, you have a stairwell or an air conditioning room, those areas sometimes are considered as ancillary. But this development order has no definition of ancillary space. And if, in fact, the developer wants property and development to be considered as ancillary, it must come back to the board for that approval. Now, it is true that some ancillary space has been granted in other areas in Sandestin, but this was done unilaterally by the developer. Next. Based on our analysis and Ms. Bradley's analysis, we believe that there is an increase in commercial development entitlement by 108,274 square feet above what is authorized. Next. Now, the third category was that there's an unexplained increase in residential acreage. Go ahead. Now, the total acreage in 1984, 2004.6, as supplemented, they're claiming that the actual development is this size, a change of 58.28. And that may be based upon their ground truthing. We don't know that for sure. But they showed 825.1 acres in 1984. Now they're claiming 1,009.5 acres, a change of 184.4 acres of residential use. Next, please. Now, so we took that number, and there were two additional residential areas that were brought into the DRI in the past. 1989 Bayou Estates and 2004 Mac Bayou Estates for a total of 56.3 acres. Subtracted that, and we have 128.1 acres of residential that we can't account for. And we have asked repeatedly, tell us where that acreage came from. What's important to remember in this, these are their numbers, but all of those buffers that we looked at, all of those medians that they've been including, that acreage should be reducing the residential component. That's property that used to be residential. They're now treating it as open space. And so that 128.1 acres is actually probably higher. Next, please. In conclusion, we do not believe Sandestin is in substantial compliance. These are deficiencies which we believe create significant regional impacts. And this is not to say that it cannot be brought into compliance, but it needs to be brought through a notice of proposed change, making these adjustments to its development order so there is a clear guide going forward as to how this DRI will be operated, managed, and evaluated. And as I indicated, Ms. Bradley's here for any technical questions. Otherwise, we're open to questions at this point.
Any questions from the board? Seeing none, thank you, Greg.
Thank you, Mr. Chairman. We have nothing else to present on behalf of staff.
Thank you.
Thank you. The next presenter would be the Sandestin Owners Association, represented by Mr. Vorbeck. I'm still holding you to the hour, by the way.
Thank you. We just need a minute or so to set up. If we can, real quickly, just for the record, I'm Gary Vorbeck, and to save time, I'm attorney out from Destin, Florida, and representing Sandestin Owners Association, or otherwise known as the SOA. You heard about Ms. Gray's report. I would like to hand out copies to the board, and I'm sorry you don't have copies. We sent them to everybody else seems to have them, but you all. We sent them out to everybody 10 days ago, and I apologize you don't have copies of it, but I don't know. But I'm going to make sure we do. This will also be on, parts of this will also be for, on the screen. Yeah, now this, one of these for the record, it's not, you got a copy, this is for the record, this would be, SOA's exhibit number 1. Is Mark around?
You can go ahead without him.
Okay. Mr. Chairman, if it's okay, I'll begin. If it's okay, I'll begin. Again, to start over, my name is Gary Vorbeck, and I'm an attorney from Destin, Florida. I represent the Sandestin Owners Association, or the acronym is the SOA. First off, I want to start off by saying I was totally impressed by the staff's job. They did a wonderful job, and I'm very, very, very pleased with their work and effort that they put in it. I know how many hours and effort and angst that Renee has put into this, and I just really want to give them a big attaboy for that. We have some issues, and we'll go into those in detail. And what I'm going to do is, just to let you know, a little bit more traditional. I'm going to just give a couple minutes here, and then I'm going to turn it over to Wendy. And the bulk of the presentation is obviously going to be by Wendy Gray, who's our land use planning expert. A lot of the issues we're going to follow is on open space and some of the same issues that staff has brought attention, but we think there's more. We think there's 5 different issues in particular, but let me start off, and then we'll go ahead and let Wendy. I know you want to hear her more, a lot more than you want to hear me, so I'm going to keep mine short, and I'll bring up Wendy Gray, and she'll explain it. Then I'll have a few comments there at the end of her presentation. So first off, as we said, I represent the SOA, and the SOA represents approximately 4,000 homes within Sandestin, and we estimate that it represents 14% of the Walton County real property taxable value. That's hard to believe, but when they add it all up, 14% of the value of the county is within the Sandestin boundaries. And the mantra, and you've heard this before from us many times, that the mantra of the SOA is not try to stop development when Sandestin. That's not what they want to do. But what their mantra is that development must follow the law. It must follow the law. That's all that they ask. And they feel that the protection of their values will be protected if that is done. Now, contrary to this, and quite frankly, it appears to us that the developer's mantra, and as the staff has hammered on in great detail in the last few minutes here, but it seems that the developer's mantra is the developers above the law can develop any manner it sees fit, regardless of the comprehensive plan, regardless of the land development code, and without regard to their development order. And I think Greg pointed out to you all the things they want to do. They change the rules as they go on, change the reports to make it say that's what they have to follow. So I think you can see that the SOA's position compared to the developer's position is 180 degrees different. Now, I do want to compliment the county, and we're very pleased that the county is now insisting that the developer follow is required to follow the Land Development Code and the Walton County Comprehensive Plan. That's extremely important, and that hasn't been the case in the past, and so we want to give kudos to the staff and the board to make that, that has made that happen. And another thing that's very important and we're very pleased with is the board and the county have required now that all development within Sandestin that qualifies will be heard as a major development order and a major development process. And if it's required to do that, it meets the requirements of the Land Development Code. Well, that's so important. The large and a great deal of abuses that have taken place in the past is because the lack of public hearings in front of the Planning Board and this Board of County Commissioners. We think we wouldn't have a lot of the issues that we have with Sandestin, or anybody would have any issues, as many with Sandestin, if they were required to go through this public process like everybody else is required to do. And so we thank you. We appreciate that decision the board has made and staff has made. Now, in following in continuation to follow the law mantra, the SOA is asking the board to make a developer abide simply by the terms and conditions of the Sandestin Development Order. Quite frankly, the developer Sandestin has often ignored its own DO, basically developing in any manner it sees fit without regard to the constraints of its own development order. We're going to have Wendy Gray here testify in a minute, and she'll provide the expert testimony detailing the developer's failures. But before she begins, I want to just make a couple points and I'll get out of here. Sandestin, with all its years and all its discussed complexity, is really a simple DO. It allows for 3 types of development categories. Open space, you heard that talked at great length. This non-residential, they call it, that means everything else that falls in that category, commercial, whatever, falls in that category, non-residential, and residential. So 3 categories it's allowed. The open space category that's provided in the development or designates the type, location, and as Greg pointed out in great detail, their location problems, that they're not getting those approved, not getting them changed. But importantly, and very importantly, the minimum number of acres of open space is specified and must be adhered to. Open space is extremely important to the ambiance, environmental health, and property values within Sandestin. You all know this from your experience in land use, how important open space is to a development. It's even more so for the size of Sandestin. Now, your non-residential category is provided in DO, designates the maximum, caps, a maximum amount of square footage of non-residential that's allowed. Allowing the developer to exceed that limit, allow them to exceed that cap, will cause traffic congestion, lessening of the Sandestin ambiance, compatibility problems, and the lowering of the values, ultimately lowering the values within the Sandestin homes. Now, through Ms. Gray's testimony, the SOA will demonstrate to the board, number one, that the Sandestin developers failed to provide the required number of acres of open spaces as defined in the DO to the detriment of all property owners within Sandestin. I think we'll even go farther than the county did. We're not giving them any credit for anything they're coming up with this new ideas because they haven't come in front of this board and asked for those changes. So we're saying we're using their numbers and using their numbers against them. 2, the Sandestin developers exceeded the mandatory maximum cap of square footage for the non-residential land use category, further harming the Sandestin property owners. 3, the developer over the last several years, and you heard Greg allude to this, last several years of annual reports attempt to hide these violations and cover up the non-compliance issues, and these reports are not in compliance with the required reporting format. Number 4, Wendy Gray will prove to this board that Sandestin has turned Baytown Village into a virtual carnival with issues not authorized by the development order. The development order can only be amended one way. That's by this board. And they're creating uses there in Baytown far from what was originally planned and what they have authorization for. And if you might remember, just anecdotally, it wasn't that long ago, they were trying to bring a Ferris wheel there. 5, and this is the final one. Ms. Gray will detail the commercial uses that Sandestin developer has created at the Baytown Marina. This is contrary to the DO. It is allowed for a marina. It doesn't say anything about the commercial uses, and they have many of them there, and she'll go through those in detail. So simply, and quite really, it's very bluntly, it appears Mr. Matthews' client wants to squeeze every last dollar out of development profits out of Sandestin without any concern for the law, for the county, or for the thousands of Sandestin homeowners. And the SOA believes that they're chartered to protect those homeowners and ensure that the law is followed, which would assure that the current Sandestin way of life is maintained. So at this time, I'd like to introduce Ms. Wendy Gray to go ahead and testify, and then I'll have a couple concluding remarks that are finished.
All right, thank you, Mr. Vorbeck.
Mr. Chairman, I have one little housekeeping thing. Mr. Vorbeck, I'm going to mark your expert's exhibit, which has already been admitted into evidence, says SOA objectors exhibit number 1. Is that
Fine with me.
okay?
Okay, Ms. Gray. Just come forward, state your name for the record, please.
Mr. Chairman, just real briefly, put this on the record to make sure, because Mr. Wolf was going to talk about this. Dana Matthews on behalf of SDI. The approval process that you went through this morning, adopting the agenda and the protocol, adopting Mr. Davis's May 22nd letter. In that letter, he said we will only be addressing the issues that were raised by staff in that staff report. Ms. Gray's report goes further. For instance, the marina issue that Mr. Vorbeck brings up, outside the scope of what Mr. Davis said that would be heard today. So I'm bringing it up. I'm objecting to any testimony or report based on things that are outside the 4 limited issues that we were told that we would be having to deal with today with this board and staff. So I'd like a ruling from the chair on that.
No, this board, these issues were brought up, if you remember, 6 months ago, we started this process out. 6 months ago, we brought these same 5 issues up then. These same 5 issues, Mr. Matthews has been aware of literally for 6 months.
Okay,
and so we haven't hit any of this, and that's silly.
My recommendation would be to allow the testimony, and you can consider it for the weight it's worth, understanding Mr. Matthews' objection.
So, okay, we'll do it that
You'll
way.
find out why they really don't want Wendy's report in the record, that's for sure.
Ms. Gray?
Good morning, Commissioners. My name is Wendy Gray. I'm the managing member of Wendy Gray Land Use Planning, LLC, a land use and planning consulting firm in Tallahassee, Florida. For the record, my address is P.O. Box 6574, Tallahassee, Florida, 32314. And I've been retained by the Sandestin Owners Association to look at these issues of the extent to which development within the Sandestin DRI, Sandestin community, complies with the development order for Sandestin. Before I go into that a little bit more, I would just like to give you a little bit of background for the record. As I say, I have a consulting firm dealing with land use and planning issues. I've been doing that since 2002. Prior to that, for 10 years, I was the director of the Tallahassee-Leon County Planning Department, a joint planning department for the city and the county, responsible for comprehensive plannings, zonings, and long-range land use, transportation, and environmental planning. And prior to that, I was employed with the Department of Community Affairs for 7 years. I have a bachelor's degree in environmental studies from the State University of New York at Binghamton. I have a master's degree in regional planning from Cornell University, and I am a member of the American Institute of Certified Planners. As I say, I was retained by the Sandestin Owners Association in 2011 to look at the issue of the compliance of development within the DRI compared to the 2002 development order. My conclusions are very similar to the ones that you just heard from staff. My methodology was a little bit different. I was specifically directed by the SOA to use and basically accept the figures that were put in the annual reports by the developer. So I was not tasked with trying to verify them or validate them or manipulate them in any way. So what I have done is looked at that data from 2011, 2012, and again, of course, in 2013, as you've noticed, to reflect the updates to the annual report. In addition, as I was preparing this, I also looked at the 2009 annual report. I have reviewed the staff responses to the various annual reports. I have reviewed just not the 2002 development order amending the DRI development order, but the previous subsequent amendments to the development order. I've conducted numerous site visits as well as frequent conversations and meetings with county staff to confirm and verify my understanding of the conditions related to the development. So with that as background, I would like to briefly walk through the 5 issues. And the first one, excuse me, I'm going to get my clicker here. The first issue I'd like to talk about has to do with open space. And I will, is it easy for everybody to see this rather than using a board? Is this okay for everybody? Okay. And this same table is also on page 3 of your report, if that's easier for you to look at it there. But basically, what we're doing is comparing the 2002 development order to the 2013 annual report submitted by the developer. What you see here is a list of open space categories. As Mr. Stewart mentioned, in the 1985 supplemental material, open space parcels, open space property was identified under the specific and unique parcels. They had parcel numbers identified, associated with them, and a particular category of open space. So you would see parcel X was lakes, and it would be so many acres, and that's how it was all identified. So as of 2002, this was how those open space categories were quantified, were divided up by the 2002 development order for that total of 1,056.7 acres. Here you see those same figures as they were reported in the 2013 annual report, and that number comes to 919 acres. And in the right-hand corner column, you can see where the differences are. And I would note that, as was discussed about the right-of-way, an increase of this 919 acres, just over 72 acres result from additional right-of-way being added to the open space category. So the question becomes, however, as Mr. Stewart pointed out, the report identifies 1,139.64 acres of open space. Where does that difference come from? And that difference comes, as Mr. Stewart pointed out, from parcels that are not designated as open space, but from parcels that are designated for non-residential use or residential use. And small pieces of pervious, undeveloped landscape property have been added, and they have been given the title of green space. And that's how they appear in the annual report. So the key significance here is, first of all, these parcels were not designated for open space. They cannot be unilaterally changed to another category. And secondarily, the category of green space does not appear anywhere within the development order. And your staff has repeatedly told the developer, and DEO has noted in their correspondence, that the annual report cannot be used as a mechanism to create a new land use category. Okay. And I'll be happy to take any questions as you have them.
Any questions? Seeing none.
Okay. The next issue that I wanted to address also has to do with non-residential development. And again, my methodology was to use the information that was provided by the developer. And this table, if you'd like to follow along in your package, is on page 6. But I think there's an easier way to kind of try to follow it through. Again, I use the 2002 as the baseline. In this case, I use the 2011 annual report. Mr. Stewart alluded to this. After 2011, the 2012 and 2013 annual reports do not contain a full accounting of the development that's classified as ancillary. So it is not possible to determine the complete amount of development from those more recent reports. If we go back to 2011, you will see that category of ancillary there, but you will also see the amount of development that's associated with that, and that's why 2011 was used in my analysis here. So just to walk through this quickly, the overall number of square feet that was approved for non-residential development, commercial, club, and community services was 1,021,895 square feet. Million, 1,021,895 square feet. The amount of development that the DO would classify as either, that the developer now grouped into a single non-residential category of commercial, totals of 619,976 square feet. So this would seem to appear that there is a considerable amount of development still to occur within the Sandestin DRI. However, then we go to the next two categories of development as they were reported. The first one is the amount of development labeled by the developers ancillary in non-residential development. And that would be development that the developer calls ancillary that occurs in a parcel that was designated for commercial, club, or community service use. Okay. You add all that up, and there's your figure there. Then the 243,000. Then there was also ancillary development that was classified associated with parcels designated for residential development. Okay. And there you see that total there of 178,387. If you add this total amount of ancillary development together, you get that total of 453.5 thousand square feet of development that's called ancillary. Given the cap of the approximately 1,021,000, you can see there's actually overbuilding has occurred. Now let me discuss a couple of things about these numbers. First of all, there has been some discussion about what ancillary is and what ancillary isn't. The fact of the matter is that ancillary is development. Number one, again, the ancillary category is not contained within the DRI development order. And again, as your staff and DEO has said, the developer cannot unilaterally create a category within the DRI. They must come to the Board of County Commissioners for approval. So the first issue is this use of an ancillary category. The second issue is that the developer is presuming that this development, the 422,000, do not count against the cap of non-residential development of the 1,021,895 square feet. There is no basis for excluding any non-residential development from that 1,021,895 square foot cap in the DRI development order. There is no basis for that in your comprehensive plan, and there is no basis for that in your land development code. And in fact, your land development code, and I have this language, if you will turn to page 7 of your report, your land development code actually does speak of ancillary or accessory uses, as the term is used there, and says in part that buildings regulated by this section shall be included in calculations for impervious surface, floor area ratio, or any other site design requirements applying to the principal use of the lot. So we could find no evidence for not counting any non-residential development against the cap. You can just go ahead and turn that off. The next three issues I'd like to cover, the first one has to do with a lot of this discussion that we've had about the annual reports generally. In 2009, 2011, 2012, 2013, these issues of ancillary space, of classifying non-residential development, of creating new land use categories such as green space, and in some cases even changing the amount of square footage associated with parcels, have all been conducted or transmitted through these annual reports. And in each case, as you will see in my report, staff has consistently responded to these annual reports, explaining what needs to be done to correct them and indicating that a notice of proposed change needs to be submitted in order to clarify and to correct these issues. And I will not read them, but I will refer you to basically pages 10, primarily 10, 11 of my report, where I provide you with excerpts from your staff responses to these annual reports. And so it's this pattern of presenting information in a manner that's not consistent with the development order and that has precluded or made extremely difficult, as your staff has pointed out to you, to understand exactly what's happening and confirm that whether or not there has been compliance. And given the fact that this has occurred over a period of years, we do believe that this is a substantial compliance issue. The next two issues that I would like to discuss, as Gary Vorbeck pointed out in his comments to you, this is a development order adopted by the local government. And while there are regional issues that at some level need to be addressed and mitigated, the development order also very much affects the local community, the character of the local community, and the quality of the life in the local community. And those are also the responsibility, those are also addressed in the DO and need to be monitored and correctly implemented. The first issue that I'd like to address has to do with Baytown Wharf Village. As we've said repeatedly, when you look at the 2002 development order, any of the development orders, every parcel is given a specific use and density or intensity associated with it. In this case, the Baytown Wharf parcel has a very specific use. It's not commercial. It says pedestrian retail, which is different than just a general commercial use. It specifically says retail, and for a number of years, that's how Baytown Wharf was developed. In the last several years, there has been a substantial development of amusement and entertainment uses. If you've been out there, you've seen them: zip lines, bungee jumping, ropes courses, tugboats that are operated by machine, golf putting. There are arcades made available, and a number of these activities are marketed collectively as the Baytown Adventure Zone, for which passes can be purchased. And the significance of this in terms of implementing the DO is that the character and the impacts associated with amusement and entertainment uses are significantly different than one might expect from retail uses. The hours of operation, and I would refer you to my exhibit, I think it's 6. If you go to page 29, in my report, you will see in those exhibits the types of attractions that are listed. We've also highlighted the hours of operation, or 7 days a week, from 10 a.m. to 10 p.m. So the types of activities, and you can see them again on the second page, page 30, of the various types of activities. The time of day, the potential parking impacts are different than traditional retail. These potentially different impacts have not been evaluated and addressed. We think that's a very significant issue. And the last issue I would like to refer to has to do with the marina. Again, if you look at the marina parcel in the DO, it's quite plain. The only use that's permitted in the DO is a marina. However, it's very clear that that's not what's happened there. And again, you can refer to page 32 of my report, and I have visited the marina site. There are numerous other commercial uses: parasailing, dinner cruises, restaurants, retail, other uses that have been developed there that, again, have an impact on the number of people visiting, traffic, and parking, and that those impacts can very much impact the quality of life for the residents of the Sandestin Owners Association. And again, this has not been brought forward to be corrected through the notice of proposed change process. These issues individually, but I think also very importantly cumulatively, signify that development within Sandestin has not been occurring in a manner that is in substantial compliance with the development order. And again, my conclusion is that it would be appropriate for you to find the development is not in substantial compliance with the development order. And I'd be happy to answer any questions.
Any questions? Seeing none, thank you, Ms. Gray.
Hang on just a second. The applicant or developer has a right to cross-examine this witness if you choose to do so.
That's not what the procedure that y'all sent us on May 22nd, nor what was adopted this
Well,
morning. So
I just want to make sure you know you have that right if you want to do so. Well, the case I attached gave you that right, so.
So I assume he's declining.
Okay. I've had a request from one of the commissioners to take about a 10-minute break, and we're actually ahead of schedule, so y'all have any?
Well, as long as it's done,
I'll add it to your 10 minutes, because you're supposed to be done at 9:40. You can be done at 9:50. We'll come back in 10 minutes.
we're way ahead. So
Okay,
that'll be fine.
proceed.
You want to take it now?
No,
You
let's go.
want to finish him? Okay.
How much longer you think you got?
5 minutes.
Okay.
Okay.
Okay, but the first thing in regard to that, we're about 30 minutes short of what we were allotted. And so what I'm asking, it's written now, I can't cross-examine anyone, and I understand that, and I'm held to that standard, and I get that. But there's going to be a lot of testimony after this, and I would just like, because I'm being so short on this, to have 5 minutes at the end to be able to rebut anything. No longer than 5 minutes. But I would like this board to give me 5 minutes at the end to rebut, because you're going to hear hour after hour after hour of testimony, and I would just like you to have the benefit of Wendy Gray, basically speaking, for 5 minutes, or combination of both of us, but no more than 5 minutes, to say, look, this is this, and I'm cutting it short by 30, so just give me 5, and that's all I ask.
I didn't schedule that. I'm going to suggest to the chair we not do that. If Mr. Vorbeck has a specific issue on rebuttal, we have set aside time for the staff to use rebuttal. He can get with the staff and present it through
That's
them.
not the same. I mean, that's not Wendy Gray, and you might benefit because she's going to hear a lot of things today. She could comment on it, and believe me, it's not going to take any time. I'm cutting it short to do that.
I think the only rebuttal should be allowed by staff.
Agreed. That's what we're going to do.
All right. Okay, so what we've asked this board to do in close here, and this is apparently the last time you're going to hear me speak today, and I know that makes you all happy, but the attorney in me is just going to growl all day long. What we asked this board to do is clear. It coincides with the overwhelming evidence that's been presented up to today, and you're probably going to hear more. We asked this board to find the Sandestin developer has failed to act in substantial compliance with their development order. Ms. Gray has shown that, 1, the Sandestin developer has failed to provide the required number of acres of open space that is defined in the development order. 2, that the Sandestin developer has exceeded the mandatory cap of square footage for non-residential the land use category of non-residential. 3, over the last several years, and Greg Stewart hammered on this heavy. Wendy pointed out to you clear that the developers' last several years of annual reports attempt to hide these violations and cover up non-compliance issues are not in compliance with the required reporting format. 4, that the Sandestin developer has turned Baytown Village into a virtual carnival, which is definitely was envisioned or authorized by the development order. And finally, Ms. Gray testified that the unauthorized commercial use that the Sandestin developer has created at the Baytown Marina is contrary to the development order and does cause problems with traffic and parking today. Now, the board has taken several steps, as I mentioned earlier in my opening, several steps to ensure that Sandestin is developed in accordance with the law. The board is asked to take one more step to make sure Sandestin is developed in accordance with its duly adopted development order. I think you're going to send a message today, when you make a decision, one way or another. Are we going to make developers adhere to their development order, or are we not? And that's the message that's going to be sent today overall. It's overriding Sandestin. It's important across through all development in Walton County. And as you know, and as you can see, and as you'll hear, the Sandestin developers have sung and danced their way without being held accountable for 30 years. It's time for that to stop. You're going to hear much singing and dancing today from Mr. Matthews and his clients. Please don't let them get away with it again. And then on behalf of the Sandestin Homeowners Association, we thank you for your time, we thank you for your attention, and we thank you for your patience.
Okay, thank you, Ms. Warbeck.
Mr. Chairman, I would suggest we take a break and come back at 10:30, and it'll be Mr. Heath.
Heath, then, okay. We stand in recess till 10:30, and we will promptly start then. Okay, please come to order. Thank you. All right. Mr. Davis.
Thank you, Mr. Chairman. The next scheduled presenter would be the Driftwood Group, who is represented by Sean Heath. We're starting at 10:30, so Mr. Heath, you have till 11:30.
Thank you, Mr.
Okay.
Davis.
Mr. Heath, you're recognized and proceed.
Thank you, Mr. Chairman. I have been before the board a number of times. As you know, I represent the folks in Driftwood, who is a portion of Sandestin. What I want to talk about is something that hasn't directly been addressed yet by the first two presenters, and that is this reduction in the open space has unquestionably occurred. We have the expert opinions on that. And what I want to discuss is why, how, where it occurred, and its impacts on the humans who live in Sandestin and more particularly in Driftwood. And so here we go. As you know, Driftwood is this upper peninsula part of Sandestin in the northern portion. And it's approximately a quarter of the gross acreage of Sandestin, about 400 acres. Now, back some years ago in 1979, the exterior was platted lots, but this interior is what's going to be at issue for today, because this interior has all been historically, predominantly all of that acreage has been open space under the Sandestin DRI. And under federal law and under state law, it's also wetlands. It shares both categories. Now, what's important is much of the open space problems in Sandestin center right there. Now, this is what Driftwood looked like before the interior of it was developed in or around beginning in around 2004. So you can see it's green. It's under the DRI. It's designated as the open space, green space category. Under federal law, it's also wetlands and DEP wetlands predominantly. Its total acreage is about 200 acres gross in here. Now on the exterior, this just shows the exterior aspect, and then when I refer to the interior, this is what I'm talking about. Now, this is another look of what Driftwood looked like before any significant construction on the interior happened. So this is the perimeter road in the exterior, the northern tip of it, and you can see all in here is wooded, and it's actually boggy and wetlands. And we know it's wetlands in part because Driftwood, the developer, the prior developer was a company called IntraWest. They owned it for approximately 20 years up until 2010, and they created a number of analyses about what they wanted to do with Driftwood. And they identified, they knew that the interior portion of Driftwood contained approximately 118 acres of wetlands. And you see down here, it was 118 acres of wetlands at the time they were writing this, which was in the early 2000s. This is a wetlands delineation map. The red, the hatched, and the red all indicate what are wetlands here. So the point of this is that Driftwood was like a bowl. On the exterior was the high aspects, and in the interior was the trough. And so the natural historical flow of water was into those wetlands. It made sense. That becomes significant for reasons we'll talk about in a little bit. Now, it was an obvious place for the Sandestin DRI folks to designate as wetlands, as open space also under the DRI, because it was area that would be difficult to be developed under the wetlands permitting process. So there's another look at it again. Now, the problems with the open space with regard to Driftwood really got off the rail in about 2000. Now, this is significant for this reason. Miss Bradley's report, the Walton County staff report that came out just a few weeks ago, on page 9 of that report, at the bottom, the staff concludes that there's at least a decrease of acreage of open space of 71 and change acres. And then it goes on to say this sentence: this amount is also without considering the additional unaccountable increase in residential acreage of 128 acres. So the same fundamental question that Walton County has been asking of the developer for about a decade of how are you appropriately accounting for your open space and this corresponding increase in residential acreage, I'm going to explain to you how it happened and where it happened, and there's never been a contrary explanation ever offered before this moment in time, other than the one we're going to give. Now, and the story that we're going to tell is not shown by any of our own documents. They're going to be shown by the testimony and the documents that were created by the person who owned Sandestin at the time, the developer. They're going to tell you where the residential acreage increase happened, and it corresponds in lockstep with the open space. So what that means is the open space decrease is actually far greater than the 71.58 acres that the county concluded. It's far greater than what Ms. Gray had concluded just on the she just took the raw data and said, here's what their own computations show, and concluded it was about 130 acres. But it's actually 130 acres at least, plus another 120 or so, and that's only if you include the roads and those other things that we were talking about. So the open space in 2000, this area in the center of Driftwood was all designated as open space. The gross acreage of this, again, is approximately 200 acres. Now, in 1999, the developer of Sandestin emphasized the significance of open space and green space, in part to come to the county and obtain tax exemptions for recreational impact fees for future developments. That's a significant aspect because they would emphasize, as they would go forward, that they ought to be exempt from recreational impact fees for all of their developments because they already had set aside significant open space. Well, in 2000, the developer obtained the specific open space, green space designation for the interior of Driftwood for this particular use, golf course, greenbelt, and lakes. It had always been open space, and it had always been those types of uses. At one time, it was an equestrian center. The significance is they were just changing from open space, but they still came in front of the board in 2000 and said, can we do it? Can we change the type of open space? Go from equestrian to golf center and this. And it was approved. Now, but what happened? In 2000, they wanted to restore the golf course for the interior of Driftwood and add the lakes, the nature trails, the nature preserve, all of those things. And that's shown from their own documents. This is from the 2000 NOPC application, restore the open space. And then there was an emphasis that there's an overall increase in the open space proposed as well, which made sense because they were increasing the open space in Driftwood. Now, the interior of Driftwood is labeled under the maps as parcel 561 for our purposes. And that provided that there was only 34.7 acres of the gross 200 acres that could be built on. And that made sense because it was going to be an integrated residential community. But it was only, call it 35 acres of the approximate 200 that could have any residential construction. The rest of it was all open space. And that's what the developer asked for in 2000. That's what was approved, but that's not what was done. So here again, the maps show where the open space, and again, these are the developer's own maps and designations about where they're putting the open space and where they obtained the commission's permission. So this is kind of the before and after. Before, the interior Driftwood was 4 parcels. It had been consolidated to 1. Its permissible residential acreage was that, and it had been reduced over half. and its density units was this, and it also was reduced in half. And that's what was sought and obtained in conjunction with many other aspects that the developer wanted to do all over Sandestin. But they said, look, up here in Driftwood, we're going to preserve this area as green space in large measure. Now, in 2000 and 2002, they filed these master plan maps. And they designate and show the open space is the 165 acres of these categories, which makes sense. 165 plus 35 of residential yields the approximate 200 of the total in the interior. But what happens? There again is the open space designation in the interior. But in November 2002, the developer knew that it could only develop 35 acres, 34.7 acres. And it says one of their director of development at the time is telling his bosses, per a memo, we'll only be able to sell 34.7 acres. Now, that director of development writes his bosses, the vice president, senior vice president of the director of development, and said there's complications surrounding selling off the interior portion of Driftwood because of the DRI acreage on this property is only 34.7 acres. What he meant was only the portion that could be residentially developed was 34.7. No one else could develop on anything more than that. He tells his bosses that. This poses a potential problem, he tells his boss, because the actual acreage is larger, and he realizes that. And the parcel was actually larger than he believed. All right? But he says it poses a problem. So what are we going to do? We're concerned, he tells his bosses, based on past experience with Walton County, that this discrepancy will cause our total land acres not to balance, and we'd be expected to ask to explain the discrepancy. This is what the director of development is telling his bosses in 2002.
Hey, Sean, I don't mean to interrupt you.
Yes.
Were you sworn earlier?
What?
Were you sworn in? Because I think you're testifying at this point. So.
I'm quoting the testimony of what's coming into the record of witnesses who have testified.
Okay.
I'm not characterizing it. I'm quoting from his deposition, his sworn testimony.
I just want to make sure you're.
Thank you.
We're
And all of this will be coming in, all of these exhibits and deposition transcripts. So that developer in 2000 knew that it was going to take about a year to get authorization for more, to be able to develop more than 34.7 acres, because the rest of it was open space. And they said, and this is quoting him, we expect the NOPC process to take at least 6 months, so it's going to take us until the fall of 2003 in order to change, to be able to develop more in the interior of Driftwood other than the 35. Now, this same person tells his bosses in mandatory terms, and I'm quoting his communications with his bosses. The problem is the large discrepancy that must be accounted for under the total acres. In order to make this change to the DRI, it must be done in an NOPC, he tells his bosses. We must be able to show where the extra 75 acres have come from. He was guessing at the time it was actually far more acreage than that. And we must complete a reconciliation through the entire property. None of that gets done. So the Interwest Director of Development, I asked him the question, would it be fair to say if you believe you could develop up to that size and density, that you did not believe you could develop more acreage and greater density without going through the NOPC process? His answer, yes, I would agree. We were saying we could get immediate approval to build for a project that was 34.7 acres, but if we wanted to expand it, we would have to go back through additional approvals. Never happened, and they knew it. Now, my question to him was, he had gotten some pushback, and he says, but the decision would, I'm sorry, the actual first portion is his testimony. He says a decision had been made to find a buyer if the price was right to sell it. And in fact, he writes, no, in fact, it hadn't been made. When he wrote his memo, he was getting pushback because he was telling his bosses that they were going to have to get these approvals. So what he was proposing didn't meet the company's objectives, as he says at the bottom, and they wanted us to be more aggressive. And they said to him, you need to expedite. This survey needs to get completed. Let's get this reconciliation done faster. We don't want just to sell it as a parcel. Let's sell it in its entirety and figure out a way to do all of that all in one. So the pushback was not to sell the 34.7 acres, but was to accelerate the sale of all the interior. His bosses were telling him, we want to sell the whole thing, not just the 34.7 that can be developed. So how was it done? So he understood after sending this memo that his instructions were to accelerate the sale in the present fiscal year for then developer. Yes, at that time I was recommending and saying, here's my thoughts, here's how we should proceed. And his bosses told him, came back, we would really like to see this happen this year, so figure out a way to make it happen. His own testimony, my question to him, he was getting pushback. Question was an NOPC necessary? I mean, it was all of those things. They had a willing buyer that was willing to do this. We wanted to figure out a way to get it done. So let's get the reconciliation done, get it quickly. He's characterizing what his bosses were telling him. And just remember, there was a lot of pressure. Let's get it done fast. That was his testimony last September. So November of 2002, what happens? A sale is negotiated for all of the 200 acres. Even though they know they can only build on 34.7 acres, there is a plan developed at the time of the sale. We're going to build 463 lots on 150 of the acres. Now, they knew they couldn't build on the center. There's a swath that runs here that is a complete conservation easement. So only of the 200 acres, the max that could ever be built on was 150, and that was even known then. So this is the development that resulted. The 463 lots were put on this side and this side, all of it eating up open space, and that 128 acres that can't be accounted for, that the county has been asking for the developer to explain for all of these years, the totals virtually match with the acreage that was developed here and here. There was all of this open space and all of this wetlands. The center swath is that conservation easement that wasn't touched. Now, at the same time, they knew they had a wetlands problem. This is a December 2002 memo that where the wetlands consultant is telling the people involved in the sale of the interior of Driftwood that areas outside the delineation and inside the ACOE fill permit, the Corps of Engineers wetland fill permit, fall under the new rule. So the environmental consultant tells them, it appears there's no active binding wetlands jurisdictional determination for the project. And he tells them, our review is that the present delineation is aggressive. It would be extremely difficult to defend in the presence of DEP the present wetlands delineation. And if the 78 acres of wetlands are filled, they would be in violation of the water quality standards because permits are not out there. All of that was ignored. So I asked him, or he said, when I wrote this memo, I specifically remember getting pushback. We were proposing, and what I was proposing didn't meet the company's objectives. They wanted us to be more aggressive. Question, so you understood after sending the memo to accelerate the sale, and the answer is yes, accelerate it, figure out a way to make it happen. So this wetlands problem and this open space problem was ignored. And so the question was, one of the purposes to avoid a substantial deviation in an NOPC process. And of course, it was certainly desired that they not have to go through a substantial deviation review because that would have slowed the sale of the property by several months, if not years. So in January 2003, the developer at that time knew that the open space was short. How do we know it? They put it in writing. We're making numerous assumptions at present to meet the best of our ability the DRI land use requirements and to satisfy the other requirements. Our current calculations have a shortfall of open space, green space. We intend on presenting open space with some of the already platted subdivisions and arterial road right-of-way as additional green space. Exactly what everyone has been talking about. The open space is known to be short in January of 2003, even before the interior of Driftwood is touched. Even before that 120 to 40 acres is developed, it's short. And so the methodology is being changed. But guess who isn't being told? The commission, the county. So the developer's own calculations in January of 2003 show an open space shortfall even before the Driftwood interior is even touched. Now, so what do? They change the method, they change the categories, they change the counts in the subdivisions. They didn't seek to change through the lawful process, and they didn't seek to do it by the process that their own director of development had identified to his bosses years before, or just weeks before. Now, in 2009, Ms. Bradley studied this and found that this 2000 reconciliation document that was submitted by the developer made many changes that were not approved by the DRI process. So it began to be recognized that this 2003 document that sought to make these changes didn't do it lawfully and sought to actually conceal the open space, the significant open space discrepancies that were known. Staff has found many discrepancies in the open space numbers throughout the years. Many issues have arisen. Now, in November of 2002, remember, the director of development had told his bosses in mandatory terms, we must do these things, we must go through this process, and it was not done. Interwest, of course, didn't tell Walton County that it was changing the methodology, changed the accounting, and it didn't tell it that it knew it had a shortfall even before it touched the interior of Driftwood. So, in 1993, there's a wetlands permit that exists for this area. Remember, I told you that the interior of Driftwood was essentially the bowl with the exterior. Well, when that bowl gets inverted, it gets filled, and that's what happens during the development. All of that water begins to shed to the exterior, and the water that was historically flowing from the exterior to those wetlands, of course, is impounded and can't flow in that direction. The permit itself says it's unlawful to deviate from the enclosed approved plans, which were premised on a vastly different design than the 463 lots. There's the permit. But that was not what was done. So the Army Corps grants the permits, but it says if you do not plan to deviate from the authorized plan or conditions, which was premised on a completely different design than the 463, far smaller, far different. Walton County, there's a traffic issue out in Driftwood. So Walton County's response to the potential Driftwood development is we need a traffic analysis and need a hurricane evacuation plan. This is the document from Walton County concerning the Driftwood development in the interior, asking for those two things, the hurricane evacuation plan pursuant to the comp plan and the traffic impacts. None of those were ever provided. Driftwood is shown, if you remember the map that was shown earlier, showed by Mr. Stewart, showed the roads that are now being included in open space. If you recall, that map showed many of the roads in Driftwood are being counted as open space. We don't think they should be counted as open space, but what's interesting also about that map is it includes roads that aren't even in the DRI as being claimed as open space. Now, these connections, in order for people to get out of Driftwood, don't actually exist, but they exist on the maps that are shown in order to give the appearance that they're in compliance with traffic and hurricane evaluation criteria that don't actually exist as a matter of fact. Now, this was approved as a minor development order, which meant it was vastly larger than it should have been. There were no public notice, no public hearings, violations of those things, and that development order was issued in April of 2003 for the development of the interior of Driftwood. So in 2004, the developer in a sense, reports his open space, although the numbers are difficult to follow because they changed the methodology. There's a legend right here that in some sense tells you about the open space. Now, if you look at that legend itself and try and add up the numbers, and you take them at this baseline of an open space requirement of 952, they're short by at least that much, and maybe that much, without including the impact in Driftwood, because they were still counting the entirety of Driftwood's interior as open space. So you would add about another 120 acres to each of those totals based on the developer's own numbers that they knew in 2004 showed the shortfall. They failed to file the annual reports, which concealed this, and these things begin to be known. So what are the impacts? What does all of this mean? What does filling the wetlands and not building in compliance with the DRI stormwater standards, which my experts are going to tell you about, result in these kind of conditions on typical rain events? Stormwater wasn't designed to retain or treat even a 1-inch standard. Mr. Waddell is going to tell you a little bit more about that, my engineer. And there's a water quality violations going on. All of these are DRI standards and serve as additional bases, in addition to the open space, to find that it's in substantial noncompliance. The Sandestin DRI standard is greater. It requires at least 2.4 inches to be retained. The state's requirement is less, but in fact, not even the state's requirement is being met, and we can prove that empirically, mathematically. Mr. Waddell can. Now, so you see the impacts in stormwater because the wetlands were improperly filled, the design standards weren't met. So what does that mean for the humans who live out there? And their yards are flooded, and because their yards are flooded, there was a mosquito infestation, the property values are diminished. Now, InterWest had a sales agent who had sold property out there for years, and he commented on his testimony that after the development of the interior of the Driftwood began, that the flooding problems began. The ground was totally soaked. My concern was all this stuff was running into the bay, and all of it was going into the bay. We have a water quality violation, we have a DRI violation, design standard violation, and this sales agent had worked out there for all of those years and said that those conditions did not exist prior to the interior development. So I asked the question, do they exist? No, they absolutely weren't there. And he had been up there after deluges, and there was no flooding until after that development began. All right. The first expert I would have address is my civil engineer, stormwater on the stormwater impacts. His name is Jim Waddell. I will give you a copy of his complete report and his CV of his credentials, but he's going to tell you about how the stormwater aspects are in substantial noncompliance with the DRI. Jim?
Mr. Waddell, you've been sworn?
Yes, sir.
Okay, if you will, identify yourself for the record.
Okay. My name is Jim Waddell. I'm a principal and president of Inovia Consulting Group in Tallahassee, Florida. Our office address is 1983 Center Point Boulevard, Suite 103, Tallahassee 32308. As Mr. Heath mentioned, many of the things that I'm going to talk about this morning are included in my report, and I'm basically going to cover the following areas. Number one, that stormwater facilities within the Driftwood neighborhood do not meet the DRI criteria. Number two, that the development of the interior of the point floods the exterior. Number three, that the wetlands work in the Driftwood neighborhood was not constructed per the approved dredge and fill permits. And lastly, the as-built, the stormwater system in Driftwood does not meet DEP or Walton County regulation criteria. In summary, the stormwater criteria in the current DRI requires the retention of the runoff from the 3-year 24-hour storm, which has a total rainfall depth of 6.7 inches. Runoff volume has been estimated in round numbers based on the current development patterns and resulting impervious area to be approximately the 2.4 inches or 30 to 40% of that total rainfall depth. The engineer of record, Campbell Engineering, for the Driftwood project, has admitted that he did not follow that criteria. As this case has progressed, it's been suggested that the DRI requirement is antiquated and that it has not been used in decades for individual projects that are located within DRI. I would tell you, frankly, that decades of doing it wrong don't make it right. I'd suggest to the contrary, that the DRI requirements initiated almost a half a century ago reflect principles in use today for stormwater management, including best management practices for erosion control, nutrient removal, and irrigation reuse. That information comes straight from the original DRI documents. Development of the interior floods the exterior. Sean showed you the bowl analogy. Basically due to the lay of the land, the development of the interior of Driftwood resulted in the elimination of acres of natural water storage and conveyances. Lands which historically drained toward the center of the point is now altered by massive amounts of fill, roads, and houses, results in water being impounded on areas of the exterior until it reaches a pop-off elevation into the perimeter ditches and then outfalls to Choctawhatchee Bay. I can tell you that I've walked this piece of property a number of times, both after a rain, during the rain, periods where there were no rain, and was astounded to find in some of these areas impounded water on the backs of these residential lots of the exterior, water, as I've described it, shin deep. I'm not going to jump up there and show you what that means, but if I take my scale, and this is the ground elevation, shin deep to me is approximately that deep to the top of this scale. The result of this condition is diminished use of private property, as well as health and safety concerns due to the standing water. And this water doesn't just go away. I mean, it's been known to stand in these backyards for days on end. Residents that live in a neighborhood like this with paved roads, with some with curb and gutter, others with swales, it's just not a normal occurrence for that to happen. The wetlands work was not constructed per the approved dredge and fill permits. As the slides illustrate, the dredge and fill permits for the Driftwood area authorized filling of wetlands, construction of stormwater management facilities, and creation of wetlands. Conditions of these permits contain provisions for mitigation associated with the work in the form of littoral zones, areas in the proposed stormwater ponds which provide water quality treatment. The engineer of record for the interior of Driftwood did not follow the conditions of the permit. He provided a design which deviated from the permit, and by his own testimony declared that the permitting agencies really didn't care if there was a deviation from the permit. Rather, as long as he stayed under the amount of impact, the number that was in the permit, it would be fine. As Mr. Heath pointed out, it's explicitly stated on the face of the permit that a deviation to the work that was authorized is simply unlawful. Consider for a moment, if you would, the implication of the development in the interior and that the permitted mitigation was not provided. The work that was originally authorized by the dredge and fill permits, which contained some amount of development on the perimeter and a vast amount of green space and construction of stormwater management facilities and wetlands. And the fact that it's part of an overall strategy for the development of Driftwood, or for Driftwood and Sandestin, to provide mitigation for those impacts. If we put all those pieces together relating to what is obviously an abandoned strategy in favor of additional development of residential units, it's not unreasonable to conclude that even a larger element of the Sandestin project should be deemed out of compliance. And finally, the as-built the stormwater system in Driftwood does not meet DEP or Walton County regulatory criteria. Stormwater facilities in the interior lack the required volume to provide treatment attenuation of runoff as compared to both DEP and Walton County's own rules. The design of these facilities was based, in my opinion, on a bogus determination that the seasonal high water table in the project area was several feet below the ground surface. Our experts determined that the seasonal high water table was generally within 1 foot or near the ground surface at all locations tested, and I can tell you categorically that those were in the immediate vicinity of every stormwater pond that's in the Driftwood development. Determination of seasonal high water table at or near the surface is expected. The core of that point and then areas outlying it were determined to be jurisdictional. We didn't come up with that determination. The developer's own consultants established those lines. And I will tell you that the documentation also suggests that they went at great length to preserve those delineations in the face of an expiration or a change in rules associated with the DEP delineation criteria for fear of losing ground, so it were. My observations in the field support the belief that the stormwater facilities are not sufficiently sized. Areas not modeled to be contributing area in the drainage basin were observed spilling over the facilities, as was the case of water spilling out of the wetland into the constructed stormwater ponds, and water breaching the tops of banks of the ponds as constructed at a number of locations within the development. Clearly, this happened. It happened during periods of rainfall which measurably were less than the level of service standard that is regulated by Walton County, and thus shows that it does not meet the standard. Basic framework of the stormwater management system for the area is flawed, including the contributing drainage areas, the available storage volume, and the measurements of flow. As a result, untreated runoff is being discharged to Choctawhatchee Bay on a regular basis. Residents are at times impeded from leaving their homes or their neighborhoods due to flooded streets. We've seen numerous photographs of that. Residents have indicated to me in the field that they're concerned for rising water in their backyards that stays there for days on end, that makes it difficult to mow, makes it difficult to use as a outdoor quiet space of enjoyment. And this, in a neighborhood like this, something just doesn't seem right about that. It's been said that Walton County has experienced record rainfall in recent months, and that is somehow the root of the problem. I will tell you as a professional engineer that just doesn't matter. If these facilities had been properly designed with the appropriate data, record rainfall could have been managed at least to within the level of service standards imposed by the county. And be that as it may, it remains that on the front of stormwater for Driftwood, the DRI standards are simply not being met. I'll be happy to answer any questions.
Any questions?
Thank you.
Sir.
Hang on a second. Does staff or the developer have any questions?
No questions.
No questions.
All right, real quick. The final person I'm going to ask to address you is Steve Seibert. Steve Seibert is a former secretary of the Department of Community Affairs, the DCA, which was the state agency that heads up management of DRI statewide. He was appointed by Governor Bush. But Secretary Seibert's qualifications are beyond just that, in that he is probably the only person in the state, literally, who has sat in every one of these roles. For example, he has sat in your chair. He was a Pinellas County Commissioner. He was chairman of the Pinellas County Commission. Prior to that, he was a land use lawyer for the government, for the county. Then he was a land use lawyer working for a private firm. And then he served on planning and other boards associated with land use. Since after being the secretary of the DCA, he serves as a mediator, arbitrator, and consultant for land use issues, including the largest landowner in the state of Florida. So he comes at it with a perspective from every one of those angles. And with nothing, I guess, Steve, if you would just tell them what you think about this.
Mr. Seibert, you've been sworn in.
I have been. Thank you very much,
If you will,
sir.
state your name for the record and proceed.
Thank you, Mr. Chairman, members of the board. My name is Steve Seibert. My offices are at 1334 Timber Lane Road in Tallahassee. I run the Seibert Law Firm, and I'm a partner in a strategic consulting firm called Trisect. Mr. Heath brought me into this case a couple years ago, asked for my perspective based on the experiences that he just mentioned. And as he explained it, and as I've tried to understand it in the last long time, the story was confounding to me. It's a complex story, and it didn't quite ring true with my own experiences in land use practice and how DRIs sort of evolve over time. And maybe as importantly, I was also secretary during the time frame when some of these really important decisions were made. And so I was very interested in making sure of what happened during that time particularly. And the history that Sean talked about earlier is important because it leads us to the substantial compliance conversations that you all need to determine later today. So let me quickly, and this will be brief, let me quickly reiterate a bit of the story that he told and then give you my final conclusions. Remember back in 2000 when the prior developer asked for a notice of proposed change. And remember the written justification that Sean showed where he specifically committed to restoring the golf course. And he noted that he was reducing the number of allowed residential units in the Driftwood area, and he used the benchmark 1984 DRI. Those were his words. And he added the nature preserve, and he talked about a net increase in open space. And we saw a table, and Sean talked about it, that table that limited development to 34.7 acres on parcel 561. And so if I'm you, if I'm Renee, if I'm a landowner, if I'm a neighbor, and I want to know what's happening in the DRI, then I go and I read it. I read what the application says. I look at the map. And if I'm pretty savvy, I can kind of tell the story of what I think is going to be there. And of course, that's what DCA would do as well. So in reviewing that notice of proposed change, one of our planners, Mike Sherman, noted those factors that I just mentioned, the open space, the golf course, and he found and wrote that there was no substantial deviation. If I'm an outsider looking in, that's what I see as well. So in 2002, the prior developer files for another NOPC, all right? Driftwood in that case is barely mentioned at all, just a small reduction in numbers of units. All of it really talks about another part of Sandestin. So there's no change to the wording. The golf course is still there, the open space is still there, the nature preserve is still there. It's all there. You have to look at the whole thing. The wording doesn't change. And of course, when the state looks at that, it sees no change. No significant change as it relates to Driftwood. But there is a problem here, and there's a problem for the developer, and Sean went through this in detail. The developer knows that he's limited to 34.7 acres, and he wants to build on a lot more than that. What he wants to do is that. He wants to build on the entire parcel. They go through the NOPC, and by the way, well, they go through the NOPC. It's approved by the county as a non-substantial deviation. No one that I know of ever sees that. That's not part of the NOPC. That's not discussed. No one says, oh, by the way, our intention actually is to put all of our units there and build that. One would think maybe that might raise some questions. You've just heard Jim Waddell talk about drainage issues and wetlands jurisdiction. I mean, there was no discussion of that. Where that happens, and Sean explained this, is when the developer goes to the county just a few months after the NOPC is approved and gets a minor development order for a 463-unit development. I don't think DCA ever saw that. I don't think you ever saw that. And clearly, the neighborhood never did. So all of this was done. We can argue about whether it was right or wrong. That's probably in a different forum. But the point is, it was done without meaningful notice to anybody, particularly to the surrounding landowners. And notice that their world is about ready to change. So all of the concerns that we start talking about in the substantial compliance relating to evacuation and drainage and negative impact on property values, they all arise as part of what happened here, where most people, reasonable people, would be expecting the golf course and the open space and the limitation of development to 34.7 acres, because that's what's in the application. Suddenly they see something very different. And they really start to see it. They wouldn't know this necessarily because that's a minor development order that didn't get reviewed, by you all or in any significant way, certainly. What they start seeing are bulldozers on the land, and they start asking questions. And they have been asking those questions and the same questions ever since. And that's what you all have been hearing for all of these years. Now, the question today is about whether the development is in substantial compliance with the development order. But it's easier to understand that in light of sort of the snowballing effect of what happened back in 2000 and 2002. So this is a complex case, right? But the fundamental questions about how a DRI evolves are not. One should expect that over a number of decades that a development plan will change. That's fair. And it's fair when you have new ownership that might have a different vision or when the market changes. And that's why you have a process set forth to determine through a notice of proposed change whether something is substantial or not and should receive additional review. The question is, are those changes so significant that they should be reviewed in a public forum so a full discussion can be had about their impacts? Now, some changes are significant by definition. That would be a substantial deviation. And you must review them if there's certain criteria met. And what you have are a number of experts, myself included, that say there's been a reduction of more than 20 acres. That in itself is a substantial deviation. There are other changes that may result in a local determination that the change is or is not in substantial compliance with a development order. And you've heard a lot of testimony about that today. And you've heard it from Wendy Gray, and you've heard it through your county representative from Renee Bradley. And if I say nothing else today that matters to you, if there's no other comment, might I ask you to seriously look at and confirm the work of your county staff. Renee Bradley has been consistent in her position. She has been persistent, and I think she's been somewhat courageous. She has raised the issues of the calculations time and time and time again. She's been doing it at least since 2009, where she's been very consistent in what she said. We all agree that the development is both in substantial noncompliance with the development order and that there is a substantial deviation that has occurred without review. So, let me close. You have an open space reduction of more than 20 acres from the benchmark 1984 DRI. that is a substantial deviation. There are different paths that everybody has taken to get there, but there is no doubt in my mind that that number exceeds 20 acres. There has been an increase of over 100 acres in residential that is unaccounted for, according to Renee. We explain that, as Sean has just done, that is the open space that's been lost to the development of the interior of Driftwood and replaced with 463 home sites. And I certainly agree with the Department of Economic Opportunity in the letter that they just sent you on several really important items. And this is, I really want you please to listen to me on this. They have raised concerns that the citizens in Driftwood have been raising for years. The first is that the drainage criteria set forth in the DO, in the development order, has never been met. That's what Jim talked about. That's what Sean talked about. It has never been met. And interestingly enough, we haven't heard this name today, that same finding came from Carlos Alvarez. You might remember that name. Carlos Alvarez was actually, you partially hired him. He was a special magistrate under a very specific provision of the Florida law that came in and heard testimony and made recommendations to you and to everybody about one of the issues was drainage, the other was about access. And he came to that same conclusion that the criteria in the development order as it related to drainage was not being met. And he made specific recommendations to the county that you really need to go out and hire an independent engineer to assess the 1-inch rain, the 6.7-inch issue, all of the issues that Jim was talking about. You really need to do that to get a true handle on this. And DEO says this is not something you can do by annual report. You have to, you either need to amend, you either need to comply with the requirements of the development order, the developer needs to, or you need to amend the development order through that process where you can take testimony and understand the implications of it. Those are the two ways to go. DEO is very clear about that. Carlos is very clear about that. Jim Waddell was very clear about that. And lastly, the flooded roads conversation to me leads to the evacuation concerns and the transportation crisis that was also raised in DEO's letter. And that was their number one issue. That was the one that struck them. They said this is a matter of regional concern, and they urged you to ensure the residents of Driftwood can safely evacuate. This is core public health, safety, and welfare, as I'm concerned about. This is the story. At some point in time, a long time ago, there were alternative roads that provided ingress and egress to the lots in Driftwood. Then the main access through Sandestin was blocked. So the only, and you know this, I think, but the only road that provides egress or access is a 2-lane road which skirts the outside of the development of Sandestin, and which floods. There are 3 places where Mac Bayou actually sort of hits it, and it has a history of flooding. Now, maybe in some degree when there are just a handful of people that live up there, that might be acceptable from a public health, safety, and welfare standpoint. But now you have an additional 463 units that are served by a 2-lane road which floods. You have an access, I guess, through Preserve Avenue, right? But that's locked, and it's not manned by emergency management personnel. No, they're not the ones that open it. It's a homeowners association. There is no universe I can think of where you will have perhaps now over 700 homes served by a 2-lane road in a coastal high-hazard area. And Carlos Alvarez looked at that and said, you've got to deal with it. I've looked at that, and I believe you have to deal with it. But more importantly, right now, the Department of Economic Opportunity has made that one of their key issues. I noted this morning as we walked in, the sheriff's deputy asked some people over there to get out of the lane to make sure that there was a second access point in case of fire in this room. We don't even have that for 700 homes in Driftwood. All of this cries out for a significant, transparent, and detailed review of the development order. It is your power to amend it where it's appropriate, to deny changes where that's appropriate, and if there have been mistakes in the past, please fix them. A lot of competent people have looked at this and determined that there's a substantial deviation and substantial noncompliance. All the Driftwood clients have asked for is a fair opportunity to discuss the impacts of a changed development order in a public setting based on independent data. And you, thank you, have provided the first step for that this day. In closing, in my opinion and the opinion of your own staff, the law is clear that there has been a substantial deviation without benefit of development order review. And the development is in substantial noncompliance on several grounds that you should review. Please make this situation right. Private property rights are essential to our thriving democracy, but they are not just the rights of the developer to consider. The hundreds of residents in and around Driftwood have precious private property rights as well, and only a fair and honest and open and fresh review of the impacts of this development, as required by law, can protect those rights and those lives. Thank you.
Thank you, Mr. Snyder.
Staff or the developer have any questions for this witness?
Nope.
No questions.
Okay.
Thank you.
Sean, I think
Thank
you
you.
have 2 minutes.
Okay, thank you. That's plenty. 70th anniversary of D-Day, June 6th, today. Thank you. Thank you for doing this. Thank you, Ms. Bradley, for we have been trying to get to this moment in time for 10 years, and we thank you for the audience today. You have overwhelming evidence that it's in substantial noncompliance. Whether it's 70 acres, whether it's 130 acres, as Ms. Gray says, or if it's 130 acres plus the 128 that's unaccounted for, it's vastly in noncompliance for the open space reasons, for the stormwater reasons, for the public health and safety concern reasons. There are other experts who have looked at this. You probably are aware, have spent 10 years in various forms of litigation and public hearings, spent hundreds of thousands of dollars to get to this moment in time. And much of that data, all of that data, that certainly couldn't be presented in an hour, is in all of these binders, and it will be in the record. And there's another expert who's chimed in on this very point. His name's Charlie Gauthier. He was the number 2 guy at the DCA. And he's got an affidavit in one of these things that says it's in noncompliance. And he said that 2 years ago. It will be in the record. And there's one final expert. He's here today also. He's one of our other experts. He's a land use expert. Studied it in the same way Wendy Gray did. Unfortunately, he won't have time to talk to you, but his name's Mike Herzberg. But his expert report is also going to be submitted into the record. So I'm going to move all that stuff into the record, Mark, and then I'll stand down.
I suspect we have an objection.
Dana Matthews for SDI. I'm going to, again, object to, for the reasons I previously cited, but new reasons. Now I hear there's an affidavit and an expert report sought to be introduced into evidence for people that are not here. We're objecting to that.
And just for the record, well, go ahead, Mr.
We're objecting to it not only for lack of due process opportunity to review, but the lateness that we talked about before and also relevancy.
Mr. Heath.
Okay. All of that information has been circulated. It's been in the public record and public known. It's been in the Walton County's files for years, and it's been produced. It's in these binders, as well as the deposition testimony I referenced in total is in there, as well as the deposition exhibits that we referenced. I can assure you it's not everything we've accumulated, but it's a lot. So I have basically 3 forms of binders here, Mr. Davis. The first is what we labeled experts, and they have a table of contents that identifies the resumes, expert reports, and technical information and backup for all of our experts. So that would be number 1. And number 2, the blue binders that also have a table of contents that identify the 5 witnesses whose deposition testimony has been taken. There's a table of contents for each of those, and I will give copies for the record and to all the lawyers involved. And then we have a third set of binders which are labeled Driftwood exhibits, and they are many of the deposition exhibits that go to the sworn testimony that's been accumulated in these cases. The fourth piece of evidence that we would submit are some questions that have been given to you, Mr. Davis, earlier. I would call this maybe our fourth global exhibit, and we just submit those for the record.
Mr. Chairman, hang on a second. Does the staff have any particular objections to any of these exhibits?
No, we don't have any objection.
Okay.
The board can consider what they deem as relevant.
Yeah, my recommendation would be to admit them to evidence, understanding Mr. Matthews has made certain objections.
Okay, so admitted.
Okay. Thank you. Subject to further questions, thank you for your time, and I will stand down.
Any questions? Thank you, Mr. Chief.
Thank you.
Miss Nancy Laney, I'm going to say that wrong. Nancy is next. She has asked for 30 minutes. I understand in a conversation with her last night that she is not going to use that whole 30 minutes. Maybe.
I'm going to give most of them back.
Good.
I'm Nancy Linan. I'm with Carlton Fields out of Tallahassee.
Have you been sworn in?
Yeah.
Yes, I have.
And before you go, I would assume this will be our last witness before our lunch break, and then when we get back from lunch, we can start Mr. Matthews' side of your
I
question.
believe you have on the agenda that the public speaks.
That's right, my bad. The public will speak, then Mr. Matthews.
Certainly. Nancy Linan, Linnan. I'm with the Carlton Fields Law Firm, 215 South Monroe Street, Tallahassee.
Nancy, will you pull that down just a little bit?
Better?
Thank you.
I always have that problem. I represent the Howard Group, parcels 208, 308, better known as Grand Boulevard to most of you. It is a DRI-sized project on its own within the larger DRI. And that's why we have kind of been swept into this, but I am not putting on evidence, not testifying, and not cross-examining anybody. And I need to explain on the record why. And that's why I'm giving you back your time. We have been assured from the beginning, when we knew this was going on, and talking to staff, senior staff, that no one was saying that the Howard Group was not in compliance with its portions of the DRI. As you remember, through development orders made in public, we have come in and we now have a separate map that shows our ownership and development and others, and we also have separate DRIs. We have made amendments. We're on our third one, I think, or fourth one now, coming before you on the 24th, as to our property. But we became concerned because while staff was telling us that, there wasn't anything in writing. So, you know, as a lawyer, you go, do I need to do something and get my evidence, and is this the proper forum? That was settled on the 522 memo, which was clearly not directed at us. But there was still a cloud over us that I had to be looking at. And that was at the beginning of this, someone at the Department of Economic Opportunity, which I will sometimes make a mistake and call it DCA, old brain cells, and I worked at DCA for a number of years, had said, if any developer within a DRI is found not in compliance, you shut the whole thing down. That's single-family homes if they need a permit. That's you, Mr. Howard, if you want to do anything on your property and need a permit. And that was pretty concerning because we are in the midst of some exciting things right now. As a result, I sent a legal memo to the Department of Economic Opportunity. They pulled the email and said, no, we're not making a decision on this. I go back to them, and I have kept in contact with the county's attorneys at all time and what I was doing. I went back to them after 3 or 4 weeks and goes, okay, now what? Now you pulled that. The county has asked this question. We have asked this question. What's the story? And they said, well, we don't really want to make a decision until the county determines whether there's noncompliance. And I'm going, that's not helping, guys. It's not helping the county. It's not helping any of us who are kind of being swept along with that. Went back to them finally, and the letter was issued at 5 p.m. on Friday, May 30th. At that point, I went home and had a few pops saying, only the developer that is found in noncompliance, that's the only one you shut down. I doubt the homeowners even knew that this was going on out there. But as a result of that, DO is the state supervising agency over DRIs, and it can't be overturned unless it's clearly legally erroneous. That means no global shutdown. It means there can be, because I wasn't put on notice, didn't put on evidence, can't under the circumstances, wasn't given the charges, cannot be any findings on Grand Boulevard, either to the bad or, regrettably, to the good, because we are not really a player in this. And it also means that you get your 25 minutes back. So thank you very much.
Any questions? Seeing none, thank you, ma'am.
Commissioner, what I would suggest is let's take our lunch break between 11:30 and 12:45, and we'll come back at 12:45 and take public comments, and then Mr. Matthews.
Turn the mics on so the chairman can say, sit down, let's get going. Let's go. I got it. It's time. That'll be fine. Come to order, please.
Really?
Mr. Davis. Mark.
Oh, sorry. Thank you, Mr. Chairman. We are back from lunch. It is 12:45 p.m. First, or the next item on the agenda would be testimony from the public. Lisa Minshew is an attorney and has actually somewhere else to be real quickly, so I'm going to let her speak first. We're going to limit it to 30 minutes. I might try to 3 minutes, 30 minutes total, and I might try to balance out the sides, but we'll deal with that as it comes up. Ms. Minshew, and before you start, were you sworn earlier?
No,
You solemnly swear or affirm testimony or statements you give before this board to be the truth.
I do.
Thank you.
Please state your name for the record, please.
My name is Lisa Minshew, PA. I represent K&H Development Group, Inc. and Blaylock Destin Development Group, Inc., owners within Sandestin, a property that is behind Grand Boulevard and located on Highway 98. I have requested and talked with Mr. Davis in advance of putting into the record a letter from my firm that I delivered to Mr. Davis, and I have copies for all of you here.
Yeah, we'll just pass them. Lisa, why don't you hand one to Dana? And do
I
y'all?
did
Okay.
already.
Okay.
Also, I had handed one to, you don't have one yet. You need one? Sure.
What number are we on, Madam Clerk? Objectors number. It should be 1, 2, 3, 4. 5, I
I
think.
have some more copies if anybody needs any.
This be 6. Objectors number 6. Commissioner, because it's a quasi-judicial hearing, we are required to take testimony from the public. Yes, ma'am. Yes. I'll provide it to you.
Thank you, Commissioners. As I said, I represent an owner and a previous owner of property on Highway 98 in Sandestin that is subject to the development order. I have asked and have put into the record a letter June 6, 2014 to Mr. Davis, which raises the objections and concerns of my client. My client has had a application pending since April 22nd of 2008 before this county for a development order for their 1.453 acre property within the Sandestin development order. Recently, Judge Green, the circuit judge for Walton County, entered a final judgment in favor of my client, finding that the property does have vested development rights under the Sandestin development order, which have been attached to the title of the property and were never transferred or allocated to the Howard Group, as has been alleged for the last 10 years. I've attached a copy of that final judgment for you, which is now part of the record. I would direct you to pages 8 through to the end, which really address primarily the DRI order, the NOPC from 2002, and how that should not have affected my client's property and its ability to get a permit. One of the reasons that we are here is, one, we do not believe that any compliance ruling today should have any effect on our pending application for a development order. So we wanted to put on the record and be clear that that's our position. I also understand that the DEO order of May 30th, 2014, which provides the same thing, has already been made a part of the order, made a part of this record, and for that reason we are working with staff now that the judge has entered the order to get our permit issued. Also, in the staff report that has been provided to you today that is being recommended for you to approve, there's a provision on paragraph 10 that we object to. Specifically, the second to the last paragraph, first sentence, which I address in my letter, reads that according to staff's calculations, there are 117,115 square feet remaining to be built on parcel 208/308, the Howard Group property. And I would object to the language of the Howard Group property being accepted or adopted in any way by this commission. The circuit court has clearly ruled that my client, who owns property in parcel 208, has its development rights, and that the Howard Group does not own all of the development rights in parcel 208/308. I don't understand why any property owner is mentioned in the staff report other than Sandestin Investments, LLC. There are hundreds of other property owners that have property within Sandestin that would not be subject to this compliance finding, and any reference in this staff report to the Howard Group owning all of parcel 208 and 308 is just wrong, and the court has held it's wrong. So on that basis, we would ask you not to adopt that portion of the staff report, and we would ask you to acknowledge that our client is not subject to compliance. Thank you.
Thank you, ma'am. Is there any other public comments? Oh, well, their hands went up all at one time. Alan, you first. Come forward. If you've been sworn, let us know. If not, and state your name for the record.
I have been sworn, and for the record, my name's Alan Osborne. First thing I want to say is some things that haven't been said. We talked about open space for a long time at the beginning of this and testimonies from experts. Let's make clear what open space is. Open space, according to the Walton County Comprehensive Plan, is undeveloped land suitable for passive recreation and conservation uses. So anybody that's saying anything else is conservation land, we have our own definition of it. The second thing I want to say is I came up here 10 years ago, and you can go check the record, and I brought up these same issues coming up. I came home from Afghanistan one day to find a sign and a bulldozer building a road as my notice that my property within 300 feet of me was going to change. And you've got a letter from the DEO that dated May 30th, 2014, asking you to address these issues. Issue number 1, hurricane evacuation, Driftwood Estates. Issue number 2, ancillary space. It affects the total of what goes on out there. Number 1 again, Driftwood Drive in the map. Number 2, stormwater in Driftwood Estates. Number 1 again, land use changes. And number 2, permits. All those affect us directly, and you got a letter about it, about Driftwood being non-compliant. I would tell you that another developer, D.R. Horton, is developing the center of that right now. That needs to be found non-compliant too. It needs to be found non-compliant for the stormwater testimony that you've received. And the fact is that a 2000 NOPC has adopted that area as open space, and they're currently building homes in open space. And I'm sure the applicant to my right would like the use of open space being used up to stop immediately because he's got to make up for it. So every time somebody issues a permit in there, when it's non-compliant, the area is designated as an open space and golf course. And this DEO letter says it takes an NOPC to change that. It takes an NOPC to change those drainage standards, and this says you're not meeting them. So that area definitely needs to be found as part of a development part that is not, the developer is building in there right now, and it is significantly non-compliant. I'm going to read from the declaration originally from Sandestin, that the declarant, desires to provide a means to maintain the beauty of Sandestin to ensure high-quality standards for the enjoyment of Sandestin as an integrated commercial residential development and to promote the recreational interests, health, safety, and social welfare of each owner and occupant of the portions of Sandestin. That means everybody has the same rights. And Ms. Meadows, you were the commissioner over that section for 4 years. I know you know.
Time's up.
Anybody yield their time to me? Does any citizen?
You got 3 minutes, Mr. Osborne.
So I'd like to address that. Everybody has a right out there. It's just not the right of the developer. And I had a right, and so did the people that I stood up for that can't stand up for themselves because they don't know what's going on with them. They have a right to those developmental order rights. They purchased under them, they were adopted by ordinance, and those laws are no good unless they're enforced. You can't just wave a wand and go back and say, just change it to match what you did instead of what you were supposed to do. That's wrong. That is not the way to enforce the law. And like I said, it's in the original page 1 of the development order of what Sandestin is. It's a place to live, raise your kids. We're left with no drainage, no sidewalk, a high-density neighborhood with no notice, no use, and no evacuation route that was adopted by ordinance. It was adopted by law. Ms. Meadows, like I said, I know that you know what's going on out there because you were the commissioner over that district for 4 years. Mr. President, you were out there one time, you caught the biggest mess you'd seen in the neighborhood. Mr. Commander, I brought this stuff to you several years ago, and you asked me to prove it. You've seen enough experts today to prove it, that it's not just speculation on Alan Osborne's part. And Mr. Chapman, you came to my house and put this in my door. And it says that if you're elected, that we'll put our trust in you to do the right thing. And it says that you'll lead us in doing the right thing and enforcing what's wrong, and that you wouldn't be beholden to any political power or developer, that you would do the right thing. I would ask you today, when it comes time to vote, that you lead us, and you step down from the chair and make that nomination, or make that motion that this is non-compliant. And finally, I'd like to finish with the developer's words itself. He addressed what I had to say at the last meeting, said I'd probably be happy about it if it was non-compliant. No, I'm not, because I can't undo some of the damage that's done. I just want the rules followed. That's all I've ever asked for. I'm going to quote Mr. Becknell, and it says in this article, in the United States, he said, a development order is not a popularity contest. It's a legal right. Guess what? There's $1 billion worth of individual property owners in Sandestin that think that adoption of the ordinance and those rules in this development order are their legal right too. And we should not be kicked to the curb in the name of, oh, well, we messed up. Somebody's got to make them fix it, and somebody's got to enforce the law. And it's the anniversary of D-Day, and those rights fall upon you for today. And I would ask you to consider this greatly before you make your decision. Thank you very much.
Thank you. For the record, Dr. Don Riley yielded his 3 minutes to Mr. Osborne. Next, is there anybody else come forward, sir? Have you been sworn?
Yes, sir.
Was that a yes or no?
It was a yes.
Yes, sir. Okay, just state your name for the record. Thank you.
My name's Tom Patton. I live at 504 Richter Avenue, just a mile east of here.
Hey, Mr. Patton, can you move that microphone up? There.
Okay, sure can. I brought a copy of my professional resume for the board. For those of you who don't know me, I have been here since 1979 for 17 years. I was in charge of development at Sandestin. I've worked with 4 different developers for Sandestin in one capacity or another, giving advice and consult. I've consulted with staff. I worked with Renee years ago on trying to get her files organized on the Sandestin DRI. I've been on the Planning Commission now for 13 years. I wanted to touch base very quickly on where we were in 1979, because I think we lose sight of where we've been. In Sandestin, you got there on a 2-lane road. There wasn't any crowd on the 4th of July weekend, and there surely wasn't any crowd there for 6-8 months of the year during the off-season. Sandestin, we started a bus transportation. We started literacy classes for bus transportation to get our employees down from Defuniak. We gave out free soap. We had literacy classes. We started a high school intern program to get people into the hospitality industry. We started a cable TV company, a sewer plant that became the financial backbone for starting regional utilities. We started our own phone company, so you didn't have to make a long-distance call to the east side of the property. We sponsored and started the fire district, and I served on that commission for 13 years. It became an economic driver. In 1994, I sent a clerk to Defuniak and had him sit there with an adding machine and add up all of the contributions the Sandestin was making to the county as far as ad valorem taxes. At that time, we contributed 24% of the overall county taxes. At this time, and I submit this for the record, I got copies for everybody. At this time, a report I got this week from the property appraiser and clerk's office, we've slipped to 22, we mean Sandestin, I'm sorry, I'm wearing my 17-year-old hat. Sandestin has slipped to 22%, down from 24%. I've got some of these also. Anyway, so it's important to realize that this is a very important economic driver for Walton County. Doesn't mean that we ignore rules or whatever, but it is important to realize that that the decisions we make today are very important. It's a sad moment. It really is a sad moment that we're at this juncture. In some ways, I think we've...
Your time's up, Mr. Patton, unless there's somebody out there to yield.
3 minutes to me.
Peter Boss, correct?
Okay. Sandestin's goal in the DRI was that we're a unified, high-quality resort community of 30,000 people, and that it basically be self-sufficient. I think we've basically met every one of those. I think Sandestin's basically met every one of those, except I don't think they're ever going to get to 30,000 people. It just isn't going to happen. It is a beautiful, fun family resort. They do have paddle boards at the marina, and they have a bungee jump in a retail area because they want to keep the kids busy while mom and papa have a drink, have dinner, go shopping. So I don't know if the county commission needs to vote every time we add a paddle board to the marina, and I think that's a real challenge to get into that level of micromanagement. Some things have been mischaracterized today. I mean, for instance, it was said that the DCA rejected the 1984 NOPC. That is absolutely not true. The DCA, Nancy Linnane and Jim Murley, came to my office in September of 1984 and simply said they wanted to do a little flora and fauna study and they wanted to have specificity. They did not change the 1976 threshold. All of this stuff about 1,031 and whatever, those are the wrong numbers. It goes back, we need to go back to the 1976 approved DRI for open space. Sandestin is in compliance with his open space to the best of my knowledge. And I think we've really gone astray here. This is the greenest place anywhere in Walton County, the greenest development anywhere in Walton County. We planted in 1992, we planted 400 oak trees. They're this big around right now. Swimming pools are open space. Roadsides are open space. Having golf cart paths in a road right of way or a sidewalk in a road right of way still makes it open space. And we've overanalyzed things. So anyway, I rest my case. I'm sure that more is going to come out on this. So thank you very much.
Thank you, sir. Anybody else? Let's see. Yes, ma'am. Come forward. State your name for the record. Have you been sworn, ma'am?
Yes.
Okay.
My name is Janet Reeves, and I am the owner of Footprints Gift Shop and resident of Walton County, South Walton County. I'm here today because of the unfairness of everything that's gone on in this county for years. Mr. Patton stated that Sandestin is 22% of the tax base. Well, that means that 78% of the tax base are citizens like us. And it's not fair to say because they are the single biggest that they should be given preference. Sandestin has overbuilt by at least 128 acres and more if you heard Mr. Seibert's testimony. So they have major problems, major traffic problems, major quality of life problems for not only the citizens in Sandestin, but the citizens outside of Sandestin because of the traffic congestion. Sandestin has 4 entrance and exits. They choose to only use 2 of them. They have one at Driftwood Estates, and they have one at Driftwood at Crystal Cove. And Crystal Cove and Driftwood Estates both have a 2-lane driveway, a 2-lane road ending in a lighted intersection. Now, they are trying to get a 5th one from our 10-foot family driveway. They're trying to get a 5th, and they aren't even using the other 2 that they have. So this is the type of things that are going on in the county. We spoke to one of the commissioners from one of the councils, and I can't remember which, but we asked him after one of the meetings that we attended, how can that be passed with all of the violations that they are violating state statutes, land development codes, comprehensive plan codes? And he said, I wasn't aware of any. Well, he's not aware of any because the county staff obviously did not pass those along, or somebody didn't do their homework somewhere. And so it got passed through every board up to the county commissioners. Those kind of things are grossly unfair to us who are taxpayers. The SOA is here today to try to stop Becknell's company from overburdening their property, and rightly so. But the SOA themselves are in fact trying to overburden our property. So if the SOA prevails here today, then you should also allow SOA to not overburden our property. Thank you very much for your time.
Yes, ma'am. Any other public comments? In the back, please come forward. Have you been sworn, ma'am?
Yes, sir.
Okay. State your name for the record when you approach the mic.
Hi, I'm Kitty Whitney. I'm a homeowner in Sandestin for 14 years. I also own 2 businesses in the village of Baytown Wharf, and yes, one of them is a family entertainment business. And I am also an employee of Sandestin, so one might consider that I might be biased. I'm probably one of the sole people that give Mr. Becknell enough heck to make sure he's doing the right thing all the time that I probably wouldn't be called biased in that regard. I'm only up here from a different perspective today, not so much the industrial, let's look at the statutes and let's figure it out. I do agree that all the laws should be followed. But in all of my roles, if my goals were not aligned, then I would consider it a conflict of interest. In this particular case, my goal is to first and foremost have a very high-quality lifestyle for my family. The more professional goal in my career is to maintain property values, and if not maintain them, increase them over time. And to consider that quality going forward in the future, how do we keep an older establishment developing and becoming new? In my role currently, being a business owner, I've had to go and get the correct permit to open my business. Being the commercial real estate director, I've had to be certain that me as the tenant was getting the appropriate documentation. And I do want you to know that we have indeed, in my 2 years here at Sandestin, practiced a very responsible level of participating. I think Mac and Renee can speak to the fact that I come all the time and say, what do I need next to get this done right? And to go through the due diligence process. So while they may have been a lot of botched up business in the past, I do think we're making every effort to move forward in the right direction with the right, very worthy goals. Thank you.
Thank you. Any other public comments? Seeing none, Mr. Davis.
Thank you, Mr. Chairman. The next presenter will be the developer, and we have set aside 2.5 hours for them to present. And we're starting at 10 minutes after 1, so that will be 3:40 p.m.
Mr. Matthews, come forward, please. You have the floor.
Thank you, Mr. Chairman. Commissioners, Dana Matthews on behalf of SDI. We have several people that will present to you today. First of all, I want to introduce my co-counsel, Ron Weaver and Darren Abram, who will be, I know Mr. Weaver will be coming up after me. Then we will have Peter Boss is going to present. Where are they? Ken Metcalf is a planning consultant out of Tallahassee with Greenberg Trower Law Firm, who will be presenting. Dean Burgess, who you all know, is our civil engineer that's been involved with Sandestin for some time, and Keith Danton, also an engineer planner out of Tallahassee, who's been involved with Sandestin for some time. Mr. Becknell will speak, and then I will wrap it up on closing.
If you will, just state your name for the record, please, sir.
Thank you, Mr. Chairman. Ronald L. Weaver, W-E-A-V-E-R, 401 East Jackson Street, Tampa, Florida. Stearns Weaver Miller Law Firm. We're about 106 lawyers statewide, dealing with DRIs for about 40 years. And my law practice began to wreak havoc. Thank you very much. My law practice began to wreak havoc on the state about the same month that the DRI did back in the mid-'70s. And there seem to be 3 huge misunderstandings that need clearing up this morning. Number one, who's the daddy of the open space baseline? There are 3 or 4 candidates, including the original 1976 development order, which you in this room on November the 12th, 2002, indicated was the governing order with the following words, and I quote from your November 12th, 2012 final order, including Sandestin, in which you said on page 6, paragraph 18, in the context of a question of whether or not a particular change was or was not a substantial deviation, and found that it was not. The Sandestin DRI development order was approved by Walton County in 1976. Now bear in mind, this is the 2002 indication of what are the rules of the road, including, of course, the open space baseline of 1976, which was 604 acres, total of 700, including roadways, as you will see from several witnesses within the next 5 or 10 minutes. I continue. The Sandestin DRI development order was approved by Walton County in 1976 prior to the time of the adoption of the comprehensive plan and land development regulations establishing certain rules. Therefore, the Sandestin DRI has acquired vested rights which preclude the application of the Walton County Comprehensive Plan and implementing land development regulations to the Sandestin DRI, including the non-substantial deviation changes that were proposed in this particular notice. Accordingly, it went on to also respectfully reject the claims of objectors regarding traffic because the Sandestin 1976 transportation study standards were the only ones that governed when this was decided in this room November 12, 2002. Respectfully, we believe that the other candidates for the distinction, the daddy of the baseline for the open space, respectfully, there's a big hard candidate called 1984-1985 that somehow is being foisted on you. And the reason that 1984 document does not govern, admitted by one of your staff on May 12, 2012, in a deposition on the subject of what would be asked what about this project Sandestin DRI, is it in compliance? And that particular staffer responded that apparently it is in compliance in 2012. Asked about open space, said there are 3 candidates. We've been given opinions that the 1976 order governs, which is the one that does, by the way. We've been given a different opinion that there's a 1984 governing. I'll tell you why, in a minute why it doesn't apply. And then that staffer went on May 12, 2012 to say, with respect to open space compliance or not, finding no noncompliance by Sandestin DRI, that the third candidate was 2011's annual report had a 2002 standard instead. So on the table today are 4 potential daddies for the open space baseline. Number 1 is 604 acres, 700 counting roadways, which is the governing 1976 order, which you said in this room in 2002, November 12th, was the vested governing standard. The second determinant might be that 1984-1985 standard, but the reason it does not pertain is that it is a supplement and an agreement that you were not a party to and we were not a party to. Well, then who were the parties to it? Number 1, the Department of Economic Opportunity, and in a minute we'll show why. And number 2, a couple of owners ago with respect to property where they entered into a private agreement that by its own terms did not bind successors and did prevent for that project and his, and I quote, intended use, whether and or the extent to which it is to be left in a natural condition, meaning that that was to be determined for other developers by separate agreements, if ever entered into, and after that owner not entered into, such that the standards of that alleged 1984-1985 order, agreement, supplement do not pertain in the least. The 1976 order governs in half a dozen of your documents and admissions of your staff on May 12, 2012. Second issue. If I had a mortgage for $50,000 and the guy before me went down to the bank and said, why don't you make my buyer's mortgage $100,000? Or the guy after me to try to make my mortgage $100,000. If I'm not a party to it, I'm still bound to the $50,000, not somebody else's prior holder of the deed to my house's different number. We have here a standard that we are asking you to confirm from 1976, which is the governing standard. In addition to that governing standard, we'd also like to confirm the fact that this particular body has also engaged in a number of important actions over the last 15 or 20 or 35 years with respect to its comprehensive plan. In your comprehensive plan, L is in land, 1.117, it says that a property that is vested from the comprehensive plan cannot be subjected to the comprehensive plan. So for the third time, this particular project has, by your own comprehensive plan, been vested from the comprehensive plan, and today I notice a number of the speakers spoke of, oh, well, there's this violation of the comp plan, or this violation of the current land development regulations from which this project is vested. Hundreds of millions of dollars are involved. Estoppel and due process and equal protection and takings of $100 or $200 million worth of property are at stake here with respect to the nature of what has been accumulated, bought in good faith, that would not have been purchased had these, with all due respect, surprise interpretations come along. For 4 years, this team has worked like crazy bi-weekly, sometimes twice a week, to try to work this out. Peace has not come. But that peace has not come doesn't mean we have to be wrapped with a bum wrap for the last 3 hours, that somehow or the other we're the culprit and we're developing contrary to the only rules of the road, when the only rules of the road are the 1976 development order. Forgive me. And I'm not preaching yet. It's not even Sunday. It's still Friday, Commander. She's holding her ears, and I don't blame you for 1 second. I think at this point I have expressed the frustration of 38 years of accumulating rights and then losing $100 or $150 million worth of them by interpretations which are deadly is the nicest legal term I know for them, with all due respect. Equal protection of the laws, there's an awful lot of other treatment around here. I think the equal protection constitutional provision says thou shalt not treat people who are similarly situated differently if you're going to honor the equal protection clause of the United States Constitution and Florida Constitution. You've heard a lot of that today. It traveled in 2 or 3 different places from 2 or 3 different treatments. We're asking to be treated the same as others and not have them out and us in and them safe and us dead, and otherwise treatment with respect to the equal protection of the laws. Property rights were spoken of elegantly and eloquently by several. We have some too. We spent an awful lot of money and wouldn't have bought if we'd had none of these deadly interpretations. For 38 years, there were not great records. For the last 4 years, we spent a fortune getting the records right. Now you penalize us for it. Or maybe you won't penalize us for it. Let us work this out. We've tried for 4 years, and we're still trying, but please don't deem us in noncompliance, for we're not noncompliant. We've over-complied is the bottom line. You'll see that soon from our experts who are coming shortly. How many minutes do I have, Mr. Quam?
You're doing fine.
How many? That was my opening. Now I'm about to save your ears, Commissioner, Commander. The reason why we're here is that our evidence and our witnesses, a land planner and engineer, will confirm that SDI is in compliance with the only applicable development orders, several different ones, including the really governing 1976 one. You may have heard me say that before for the last 10 minutes. That was confirmed in this room on November 12th, 2002. But I left out the best part of the deposition of your staff on May 12th, 2012, and that was this. If the 2 or 3 or 4 candidates for the daddy of this open space baseline is indeed the 1976 original order, which is called the natural daddy. It is the real daddy. It's the natural daddy. There is, and I quote your staff, nothing out of compliance. Ask again on the deposition, is this Sandestin DRI in compliance? Yes. 3 times. Yes, yes, yes. 2 or 3 candidates for what's the baseline, but yes, this Sandestin DRI is in compliance. Local governments have the right to change their land uses in their comprehensive plans through zoning restrictions using their local legislative processes, but not. You probably wondered, wait a minute, that sounded awfully reasonable, Mr. Weaver. What's the matter? I'll repeat it, then I'll finish it. Local governments have the right to change their land uses in their comprehensive plan and through zoning restrictions using their local legislative processes, but not to divest clearly vested and relied upon rights. That's been lost for 3 or 4 hours. Yes, keep changing the law to save Walton County. That's why we're here. But don't change it on the backs of folks who have spent a fortune in good faith, credibility, and reliability and sustainability of the integrity of Walton County, who've come and bothered to spend a fortune on what's here and what was in effect when they bought it and what they have accumulated. Vesting means development rights obtained through a previously approved DRI are not lost by subsequent changes in the law. Your code 2.06.02 and your code 206.01 encourage diversification, integration, flexibility to achieve community and community mixes that work, and beautiful non-squares with respect to the landscape you'll hear more about in about 10 minutes, all of which are part of what we're about here today. Sandestin DRI was approved as a development. SDI has significant development entitlements remaining. Don't take those last 1,874 units and make it look like by some of these deadly interpretations we might only have 272 left. That is a lot of money at $50,000 a unit, about $80 million to be exact, all without any basis in due process, equal protection, or without violating the takings laws, without compensation, that taking. Until a substantial deviation application has undergone agency review, been approved by the local government jurisdiction, and become legally effective, the originally adopted 1976 DRI development order and its classifications, if any, must continue to be utilized as the benchmark for substantial deviation determinations. I don't mind and I don't blame your staff for begrudging the fact that we preceded the comp plan. I'm sorry. We can't meet all of the comp plan that was not in effect when, and you said so in this room on November 12, 2002. I'm sorry. It's begrudging that we don't have to meet the comp plan, and that newbies do. And I apologize for that. But we can't rearrange everything we've done, and we can't unbuy it, and we can't unrely upon it. As a matter of due process, property rights, and contract law, DRI benchmarks could not be based upon documents that had not even been reviewed by the DCA at the time of the 1984 alleged agreement. And there are 5 other due process flaws with that alleged agreement, and I've shown you 3 or 4 reasons why it wouldn't pertain anyway. Not that I have any strong feelings on this. 380-0323 Florida statutes, the statute under which that agreement was allegedly entered into, not with you, not with us, yes, with prior owners, for their unique needs and their unique representations and their unique planning and its consequences for them with respect to a non-appeal by the DEO. That agreement ain't yours, it ain't ours, with all due respect, and the law on the subject says that if that agreement was entered into under 380-032 sub 3, says that 380-032 authority to execute agreements must not contravene contrary statutory requirements. And the contrariest contravening statutory requirement I've ever seen in my 40 years of VRI law is 163.3167 sub 8, which is the heart of it for 40 years, which says if you've got a DRI development order, you've busted it to buy the land and get the approval, then upon that you can rely. That statute was unchanged, and anything in the alleged agreement among a few other parties for a different reason would not be a 380-032 agreement, because it would contravene an explicit provision that keeps the 1976 order in effect. How many minutes do I have, Mr. Plum? 5. If the department thought the 1976 development order was not sufficient to serve as the required benchmark, the department should have appealed that order. There have been a half a dozen, if not a dozen, actions on your and the DEO's part that are contrary to this morning's bum raps, with all due respect. I don't know what to call them. This DRI has no master developer, so SDI cannot be tagged with others' problems. Hold their permits if you must, not SDI's, which has built almost nothing yet. Would like to build something, has been trying for years to try to build something, and would like to please be allowed to get on with this business for all our sake, all of your sake. It's not rational to rely upon erroneous past numbers reported by prior developers. I need to use that with my wife. Please, let's not reopen the old conversations. Let's deal with the current state of affairs rather than some reports that may or may not have been perfect a year or 5 or 8 ago on the subject. In closing, please redeem the ability of Walton County to take those who've paid good money for vested rights, that they not be pulled out from under them, because there's a begrudging desire to have them under a comp plan that wasn't in effect when they were approved, or land development regulations that were not in effect when they were approved in good faith. If this were your family and it were your family's attempt to try to get on with life, you would only ask that you be treated fairly as well. Thank you. Mr. Metcalf will speak to the particulars of that DRI law. Mr. Metcalf.
Okay, thanks, sir.
Here you go. Yeah, there you go.
If you will, state your name for the record.
Yes, for the record, my name is Ken Metcalf. I'm the Director of Planning with Greenberg Traurig in Tallahassee, Florida. Today we've heard a lot of theories about how Sandestin Investments is out of compliance with the Sandestin DRI. And I would just posit for you from the beginning of my presentation that those assumptions that have been made about the controlling law are way off base. Mr. Weaver went through it, and I'm not sure how I drew the unenviable task of following Ron Weaver. My presentation style is going to be a little bit different than Ron's. I'm going to walk you through, rather methodically, through some statutory requirements that will follow up on many of the good points that Ron made. Before I do that, though, let me just give you a little background on my professional experience. I have 28 years as a professional planner in Florida. I worked with the Department of Community Affairs for 16 years. I served as the regional administrator for the South Florida and the Treasure Coast regions of Florida. Very large area. I would say that region probably has 125 DRIs. I was responsible for making all of the recommendations for those regions with respect to substantial deviations, NOPCs, notices of proposed change, review of applications for development for new DRIs, virtually all aspects of DRI review. Prior to that, I had worked for local government for 3 years. Since 2004, I worked with Greenberg Traurig as a private planner, working with the private sector and some local governments. And in that role, I've probably worked on 20 or so DRIs in different roles. As Ron mentioned to you, the stakes are quite high here. And the statute recognizes that. If you look at the statutory language, it doesn't say, is the development in compliance? It asks, is the developer in substantial compliance? Why does it say that? Because the stakes are high. That's exactly why it says that, because there are protections for developments of regional impact for a lot of different reasons. The huge investment that it takes to go through a DRI review, just to process and prepare a DRI applications, we always quote clients, you're looking at probably $1 million, $1.5 million just to go through the initial process of the paperwork. It's a very expensive proposition. Okay, so here is the section that we're talking about today, 380.0617. So let's take a look at it together because the words are important. The local government issuing the development order is primarily responsible for monitoring the development and enforcing the provisions of the development order. No dispute in regard to that reading from us. That's what it says. The second sentence is very important. The local government shall not issue any permits or approvals or provide any extensions of services if the developer fails to act in substantial compliance with the development order. Now, you've heard today that the DRI is not in substantial compliance with the development order. That's not what the statute says. The question before you is whether this developer has acted in substantial compliance with the DRI. The history that they've given you about problems that they believe occurred in 1999, 2000, 2002, 2004, totally irrelevant to the question before you under the statute. There's a reason that the statute describes the developer as a person that's undertaking development. Development, by definition, under the statute, means that you're building buildings, you're clearing land, you're undertaking all sorts of developments as those are defined under the statute. So what has SDI done? What has Sandestin Investments done? They haven't developed any property in 4 years of their own. Let me say that again. They haven't developed any property in 4 years. They have authorized lessees, tenants, to undertake development. That occurred between 2010 and 2012. There are no code enforcement matters pending before you or with one of your agencies with respect to Sandestin. SDI hasn't taken any development actions that fall within the scope of Section 380.06.17. We shouldn't even be holding this hearing. There are no enforcement actions pending. We're going to talk about these annual reports, but before we do that, again, let's focus on these definitions. This is the definition of development. Making any material change in use or appearance of any structure or land. Further explains that the term development includes and refers to the act of developing or to the result of development. So only the developer's actions in actually carrying out development are relevant to this discussion today. That's all that's relevant. If there's disputes about how land use classifications have been defined and reported, that's a different issue altogether than a 380-06-17 hearing, which is what we're having today. None of staff's findings concern development actions by SDI. That's the reason that you've heard them have to go back and talk about this history. Why? Because they don't have any issues to talk about over the last 4 years as to how the developer, SDI, the current developer, might have violated the law. So what does the scope of SDI's development activities involve? There they are. And these all involve tenants. The Blast Arcade that you've talked about, that you've heard about today, that was issued a permit, and it was constructed after 2010 by a tenant. There's no code enforcement. There's no claim that that's in violation. There's a related storage building, 19-foot by 18-foot storage building. It's in compliance. There's a ropes course, 1,500 square feet, in compliance, no code enforcement action pending. All right, so I've dwelled on that enough. County staff findings are irrelevant. They're basically focused on disagreements over the interpretation of the development order. Again, we believe that they're looking at the wrong development order. The relevant development order is the 1976 DRI. That's the vested development. It's the 1976 DRI that was initially approved. In terms of these annual reports, let's take a look together at what the statute says about annual reports. 380-06-18 describes to you an option that's available to a developer in SDI's situation where no development has occurred. And it simply says that they can submit a letter and say, we haven't done any development. So for the last 3 years in the annual reports that we're hearing all these complaints about, we could have simply submitted a letter and said, we haven't done any development. And if that's what it takes to resolve this compliance hearing, I think I have authority to say we'll withdraw them. And we'll enter a letter tomorrow saying no development occurred, and we'll be in compliance with the statute. If that's such an important issue about how these annual reports have been prepared. I think it's off topic myself. So why did SDI take the time to prepare these reports? Part of that 4-year ongoing effort to try to resolve these compliance issues. These compliance issues that your staff keeps alleging that we disagree with. And it starts because there's a fundamental disagreement about the controlling documents. You've heard it already from Ron, and I'll follow up and go through some of those. It's improper for staff to penalize or to suggest to you that you should penalize this developer simply because they disagree with the reporting methodology that SDI has used in its annual reports. It's a very adverse, negative way to approach this issue. So if you go back and look at SDI's actions, they've directed their consultant team to try to work through these issues with staff. They worked together to try to reach an agreement on an MOU. They've taken proactive steps over the last few years to negotiate on classifications that we believe would be consistent and reasonable given our vesting under the 1976 DRI. Staff's opposed to those because they want to require that we continue to operate under some other paradigm, some other future changes that they believe control in some way from an agreement that SDI wasn't even a party to. You know, one of the most expensive undertakings a DRI developer can do in terms of its soft cost kind of planning is to do a survey. SDI actually commissioned and had a legal survey done of the entire DRI. I mean, I've worked with, like I said, at least 20 DRIs, looked at hundreds of DRIs and amendments and so forth over the years with DCA. I've never seen a developer do a parcel-by-parcel survey of the entire DRI in an effort to try to work out these sorts of issues. Tried to work out an MOU, weren't able to. That's not a compliance violation. That doesn't mean we're out of compliance because we couldn't reach agreement with staff. So let's look at the open space issue. You know, it's really important to understand, and this is really hard to make people appreciate unless you've sort of looked at these documents and compared them over time from different DRIs. But what I can tell you is if you look at DRIs from the 1970s, you know, they tend to be very generalized documents. The development order, the 1976 DRI development order is just a few pages. Today, if we did a DRI development order, that development order would be on the order of probably 50, 60 pages. It's an altogether different process today than it was back in the 70s. And that's very important because as we look at what did the actual 1976 DRI authorize and vest as legal rights, it was very broad, very broad. And that's not uncommon for these 70s era DRIs. If you go to a DRI that was developed, or excuse me, approved in in the 2000s, it's going to look very different. It's going to be very detailed. There won't be any questions of interpretation. That's just not how they did business back in the 70s. This DRI was approved a year after the legislation, actually the DRI legislation came into effect. At that time, developers didn't have any experience with the DRI process. Landowners didn't understand it. Planners were struggling to understand it. The fact is, you have a very broad vested DRI. County staff maintains there's a shortage of 71.58 acres of open space that's occurred and believe that that's a substantial deviation. Of course, we strongly disagree with those conclusions. We're going to put on a different witness that's going to walk through those calculations. But you have to ask yourself, if that were true, then why didn't staff raise those issues during the review? If there's actually been a shortage of open space as a result of overdevelopment, how did it get approved by staff? Why wasn't it called a substantial deviation at that time? Why do they come along now and suggest over 10 years later that SDI is responsible for a violation that they signed off on, evidently? Of course, we don't believe that there have been those violations, but that's their position, and I think it's a fair question for you to ask your staff. SDI has not failed to act in substantial compliance on the open space issue. So let's take a look at commercial. County staff find that there's 151,000 plus square feet of commercial development allocation remaining for Sandestin and over 117,000 square feet for the Howard Group. And yet they contend that there's been a violation. How can there be a violation? We haven't run out of development allocations on commercial use. Not even close. Their staff reports on their face confirm that there's an in-compliance situation, that this developer has not violated commercial development allocation rights. And it's important to understand what they're really trying to suggest to you is that because they disagree with the way the annual reports have been written, that there's going to be a violation. We can see it coming. That would be their view. We can see it coming. That's a perspective and speculative viewpoint. That's not what this hearing is about. The stakes are too high to speculate on whether there might be a commercial violation 5 years down the road because there's a difference of opinion on how commercial classifications were vested under the 1976 DRI. SDI is in compliance with the commercial development. And again, very important, they haven't built any. They have not built any. Same for residential. County staff find that there's an unaccountable 128.1 acre residential increase. Well, SDI didn't convert any land. They haven't developed any land. Our witness will go through why we think that's a simple math error on the part of staff, as opposed to the theory that you heard from others today. Same question on open space, though. Let's assume for the moment that staff was correct. Well, who signed off on that development? Not SDI. That development occurred before 2010. If there's a substantial deviation problem, if there's an excess of residential that has occurred, by the way, residential acreage is not the basis for a substantial deviation termination. It's numbers. It's dwelling units, not acreage. Well, let's say even if they are correct, who's responsible for that violation? Certainly not SDI. I think you need to look at your staff and ask, how did we get to that situation? So their precedents are important. On the one hand, they're asking us to try to maintain a consistent approach at the same time that they're refusing to recognize our vested rights. All the while, in our view, they simply keep changing their position on key issues. Let's take a look at ancillary space. The Howard Group property has been allocated numerous credits for ancillary space. And now they say we can't use those types of credits. Well, that's a change in position. Ron could explain to you in detail how reliance on a change brings up estoppel issues. And it's just, I don't know what other word to use other than egregious that they would change their position and then turn around and attempt to show that SDI is the culprit and somehow we've changed our position. Our position's based on our vested rights. So let's take a look at the substantial deviation process. County staff conclude that a substantial deviation has occurred with regard to open space. This is simply not correct. Look at the statute. It says section 380.0619F5 requires the local government to hold a hearing, a public hearing, to determine if a substantial deviation has occurred. You've held a bunch of them. Every single hearing, you've determined that there's been no substantial deviation, none. County staff's conclusion is not only incorrect, but it's inappropriate for consideration at this hearing. This is not a 380.0619F5 hearing. It's a different hearing altogether. This is an enforcement hearing. This is a compliance hearing. It has nothing to do with whether a substantial deviation has occurred, and if it has occurred, same question, how did your staff let that occur? We don't think it has. The county staff confuses the two issues of compliance with the totally unrelated question of whether substantial deviations have occurred. This hearing should only focus on the issues set forth in 380.0617. I'm only addressing it before you because we have to, because they raised it inappropriately. Again, the substantial deviation issue, it's important. When a substantial deviation occurs, it essentially means you start over as the developer. I know we use these technical planning terms, but there's a significant repercussion to a substantial deviation. It means all bets are off. It means your vesting is lost. It means you start over. You might as well just look at it as a brand new DRI when you file a substantial deviation application. So we shouldn't be throwing those words around loosely without any support for those findings. Those are very important findings under the statute. So what does 3800619 say? It recognizes that there's a specific review process, a specific procedure for how we review changes to development of regional impact over time. DRIs change for a whole variety of reasons, as previous witnesses mentioned. Good reasons for those changes. You have to evolve with changing times. But we have to recognize that the purpose of reviewing development orders is to ensure that there's no additional impacts over the vested level of development, That's why the vesting is so important. You can think of it as sort of some people use the word baseline, some people use the word benchmark. Terminology doesn't really matter. There's a certain threshold of impact that was approved with the original development, the vested DRI, in 1976, and if we don't exceed that level of impact, then there's no substantial deviation. Now, what the statute does to try to make that task of figuring out is there going to be more impact or not, to make that a little bit easier for us to figure out, is the statute says, okay, we're going to use some surrogate numbers. We're going to set forth thresholds. Have you decreased open space by more than 5% or 20 acres? That's an example of one of those thresholds that you've heard about. Those are the thresholds for determining whether substantial deviation has occurred. And we have case law that deals with the issue of substantial deviation, very important case law. So we have Edgewater Beach Owners Association versus Walton County. What did the First District Court rule? Recognized the statute that Ron mentioned to you earlier, 163.3167, parent 8, Florida statutes. It vests the developer's right to complete any development that has been authorized as a DRI, hence our 1976 DRI approval. That vesting continues until there is a substantial deviation. It continues until there's another DRI review, which is that First District Court's reference to the idea that you're continued to be vested up until the time that you have to file a substantial deviation. We've never filed a substantial deviation. You've never found a substantial deviation. So we continue to be vested. Now you may hear, well, Bay Point changed all of that. The Bay Point decision changed all of that. Well, it didn't really. Bay Point changed how we look at proposed amendments. And Bay Point basically says that a proposed amendment you might want to make to your DRI is not inherently vested and must comply with the comprehensive plan if it's a significant type of amendment. Then it's no longer vested from the comprehensive plan. In the Bay Point case, there was a substantial increase in density, and there was an inconsistency found with the comprehensive plan. That's simply not the case here. If you look at what happened in 1984 with the Sandestin development order, it was a reduction in density, the opposite of a substantial deviation. There's never been an intensification of this DRI. That's just, frankly, utter nonsense to suggest that there's been a substantial deviation. The statute's very clear on this. SDI has a statutory right to rely on the 76 DRI-DO. It was approved on October 19, 1976. The 1984 DO, subsequent DOs didn't approve a substantial deviation. There has been no substantial deviation. Staff's position is inconsistent with Edgewater. Staff's reliance on the 84 DO and the 1985 settlement agreements also inconsistent with Edgewater. Let's take a look at this 1984 settlement agreement that we all have heard about. This is a really important document because it, looking back at the history of this DRI, this is where things went awry. This is where the problem started because staff went off one direction, ultimately, while SDI, once it inherited this comprehensive plan, once it bought this DRI, it looked at its vested rights, and they don't quite square with what DCA has suggested in the settlement agreement. So what's the settlement agreement say? It says that DCA had problems with the 1984 development order. Now you heard from your own attorney, DCA rejected the 1984 DO. Simply not true. Simply not true. DCA did not appeal the 1984 DO. I don't know what the word rejected means. I look at the statutes. There's only one way DCA can reject, if you want to use that term, a development order, by appealing it pursuant to 380.07. Done a lot of those appeals. I just don't write a letter and say, I don't like your DRI. I didn't do that when I was with the department. If there's a problem with the DRI, you appeal it. If there's not a problem, then you don't force a settlement upon the landowner. If you read the agreement, it literally says that DCA threatened appeal. And then they used that to coerce the developer at that time to enter into an agreement. Totally inappropriate under the statute. Let's take a look at what the statute actually says. Before I jump to statutory language, let me just make one other point. The 1984 agreement cannot supersede statutorily vested rights. That's really at the crux of this matter, isn't it? I mean, we're either able to enjoy and apply our vested rights or we're not. And an agreement that was executed with a predecessor, and not even with the county, which was highly inappropriate on the part of the department, simply shouldn't be given that kind of weight. And it's not. It's not given any weight in the statute. So very quickly, the agreement does not include any provisions which make it binding on the county or any successors of Sandestin Corporation. It's not binding on SDI. The agreement required the developer to submit supplemental documents in 1985 that would define reporting requirements, documents that DCA hadn't even seen. So think about that. The department executed an agreement that's supposed to set the new approach for the DRI, and they had no idea what the documents were that were going to be exhibits to the agreement. Ridiculous. I don't know any other word to use. And more problems with the DCA agreement. Section 380.032, parent 3, authorizes DCA to effectuate Chapter 380, not to circumvent it. They have no authority to circumvent 380. Their agreement did just that because they didn't take an appeal of the DRI. 380.0619 defines very specific requirements for determining whether there's a substantial deviation. DCA didn't have the authority to set aside this board, back then, this board's determination that there was not a substantial deviation to the 84 development order, but they did just that. This agreement cannot be applied in any manner or interpreted in any manner that would limit SDI's vested rights. And yet more problems with the DCA agreement. Walton County never adopted any of the supplemental documents, the ones that DCA hadn't seen but made part of the agreement. DCA never formally confirmed that the supplemental set of documents that were submitted to it were actually required and consistent by the 84 agreement. If you look at the supplemental documents, they don't even complete the list that was required by the agreement. There's missing documents. The 1985 exhibits actually conflict with the vested development order. The way it treated open space would be an example. So the agreement doesn't have any binding effect and shouldn't be considered in terms of any of these land use classification issues, any interpretations regarding open space, commercial, residential, any of those have to flow from the vested development order. And aside from all of the statutory reasons for that, I just close by pointing out what your own order says. Conclusion of law number 16 relies on the 1976 development order, that is the 1976 vested DRI, in its application for development approval as the proper baseline for determining whether the 2002 amendment resulted in a substantial deviation. Doesn't use the 85. This board determined that you must look back at the 76 vested DRI to make that determination. I find it interesting that your staff didn't even bring this up to you. How can your staff not bring this up to you? This was done by this board. It wasn't our decision, it was your decision. Finally, conclusion number 18 orders that the Sandestin DRI has acquired vested rights which preclude the application of the Walton County Comprehensive Plan and the implementing land development regulations. Pretty strong order. I mean, it doesn't take a lot of interpretation. That's why I put the words there in front of you, because your staff didn't. So in conclusion, SDI has not failed to act in substantial compliance with the Sandestin DRI. All of these issues that your staff has raised that occurred before SDI's ownership are totally irrelevant. County staff's findings regarding the annual report are totally irrelevant. And SDI asserts its statutorily vested rights with respect to all of the land uses, classifications, and the determination of substantial deviations. Thank you.
You have a question?
I do. I have a question.
Yes, ma'am.
You know, you've outlined a litany of problems that you say exist with this DRI. Why would anybody buy a DRI knowing all of these problems? And what did your client think he was buying? And did you outline all this to him before he bought it?
3 questions. A, I don't know that he knew about all of the issues.
Okay. Do you think that he should have known buying this much property in an old DRI? Would you advise a client buying an old DRI like this to make darn sure he knew what he was buying?
I would advise a client as to what his vested rights are and advise him that those are enforceable. It doesn't, you know, no DRI is perfect. And the reality is DRIs change over time. You find inconsistencies. Even within the vested DRI itself, there are different descriptions. One table says, here are numbers. The map reads a little differently on classifications. You know, as I said, you're talking about a 1970s era DRI with a lot of generalities, very broadly written. And that's the key issue, is it was very broadly written to vest the developer with a lot of discretion in terms of how the developer can choose to develop under its vested DRI.
You stated that that he wasn't really a developer because he hadn't really developed anything. He submitted and got a development order for a place called Osprey Cove, Osprey Point, whatever. He's done that.
He filed an application.
Yeah, he's filed an application and got a DO. He's officially a developer. He put a blow up thing out in the bay. He also tore a building down and dumped the remains in the bay. From what I understand, there's a DEP violation on that. This is my understanding. You'd have to prove that out. But he submitted to build a Ferris wheel in 40 feet from some condos in Baytown Wharf. So I think, you know, when you say, well, he's not really a developer according to the statute.
Let me clarify. I didn't say he wasn't a developer. He is a developer. He just hasn't yet developed.
Well, so he hasn't yet developed, but he's submitted quite a few applications, and he's gotten quite a lot of feedback from the staff as to what the problems were.
Totally agree that he's filed applications and there's been feedback, and that's exactly why I say staff has made a prospective determination. Ooh, we're concerned there might be a violation down the road. Well, that's fine to raise those concerns. It's not a finding that's appropriate under 380-06-17.
Well, I think he bought a pig in a poke. That's what I think.
I understand.
And I think that, and then he found out that, you know, there were problems, there were issues with it. And I do believe that when I spoke with Miss Renee Bradley, she told me that when he came to see her, doing his due diligence, that she told him about these problems. So, you know, sophisticated developers who have bevies of lawyers and planners such as you, to have bought something to not know really what they could and couldn't do, is, like you used the word, I think, is astonishing.
I have one question, excuse me, just so I understand your position. Your position is that the 1984 agreement does not apply to Sandestin because the developers changed and the county was not a party to that agreement. Don't let me misstate it.
Well, I said it didn't apply for a number of reasons. Those are two of them.
Okay. So in your mind, the agreement does not, and forgive me for using this term, it's an old dirt lawyer's term, that does not run with the land, essentially. In your mind, the 84 agreement does not run with the land, does not run with the developer or with the development from 84 forward.
I didn't use those words, but I would agree with that.
Okay.
I have some questions.
Any other questions?
Want me to come up? Or
It might be helpful to hear. Yes, sir.
I wanted to see if I can kind of make sure I understood your testimony. And following up on what Mr. Davis said, you indicated that any of the obligations that have been imposed on were agreed to in the 84 agreement by the then developer are no. Are not binding on Sandestin. Is that basically your position?
Yes.
And because that impairs his vested rights, the Sandestin's vested rights?
Yes.
Now, the developer who signed that agreement back in 1984, weren't those rights his rights at that point?
I would say so.
So doesn't he have the ability to alter whatever rights he has by entering into an agreement?
No, I don't think he gave up his vested rights.
He can agree to do it, can he not?
I suppose he could. I suppose he could agree. But
And the developer
Can
who
I
agrees.
finish my answer?
Can the witness answer the
Can I finish
question,
my answer?
please?
I suppose he could agree, but I don't think that's what the agreement says.
Didn't in fact, the agreement that the then holder of the vested rights committed to is that he would submit on each individual parcel the specific allocation of uses that were going to exist on those parcels?
The agreement doesn't go into the details that are very important in the vested DRI as to how you handle open space within development parcels.
I just want to make sure I understand. You're an attorney or a planner?
I'm a planner.
Okay. So in terms of vested rights, do you think vested rights have no ability to be given up by the holder of those rights?
I think a developer can forego his vested rights. I don't think this agreement did that.
I see. And if the developer took upon himself additional obligations that he did not have prior to, do you think he has the ability to do that?
Yes.
And do you think that if those impinged or affected his vested rights, that then carries forward to subsequent developers?
Well, that's a hypothetical. I don't think that occurred here.
You don't think that it was his rights were modified by that agreement?
No.
But you're not an attorney.
I already answered that question.
Now, you indicated that the 84-85 combination, that it considered right-of-way as open space. That's different from what existed in 1976.
That's correct.
Then why did this developer submit road right-of-way for the purposes of open space if that 84 and 85 agreement did not apply?
The developer tried to work with your staff. The developer has tried to work with your staff. Doesn't mean he gave up his vested rights.
I'm not talking vested right. This is simple. Did he in fact submit right-of-way for consideration as open space?
He reported it in his annual reports.
And didn't that only occur because of that 84-85 agreement?
Yeah, he tried. Let me be clear here. He tried in good faith to work with the county under the existing agreement. That doesn't mean he agreed with the agreement, doesn't mean he was bound by the agreement, doesn't mean he gave up his vested rights.
Prior to today, are you aware of any document filed by Sandestin that indicated they did not believe the 84-85 agreement applied?
Not sure what you mean by the word applied.
Applied to this analysis, to what we're talking about here.
You mean to whether the developer is in compliance?
Yes.
Whether he has acted in substantial compliance?
Yes.
No.
Now, let me show you. I just want to see if you've seen. Let me show you a letter dated June 7, 2012 from Mr. Tom Beck at the Division of Economic Opportunity. Have you seen that letter?
Yes.
And could you read that into the record? That's fairly short. Just the body of this paragraph.
The Department of Community Affairs entered into an agreement with Walton County on October 12, 1984, as provided by Section 380.323 Florida statutes regarding the Sandestin DRI. Purpose of the agreement was to resolve the county's and the department's differences regarding the legal and factual determination that Resolution 84-24 adopted by Walton County on August 28, 1984 was not a substantial deviation. Paragraph 5C of the agreement states that future substantial deviation determination shall be made in reference to the 84 master plan as supplemented with the submittals made by the developer pursuant to Sections 3B Romanet 3, 5B Romanet 4, 3C 4, and 5A of the agreement. Therefore, the baseline for future substantial deviation determinations would be that associated with the 1984 master plan as supplemented by the data and analysis required by Section 3B Romanet 3, 3B Romanet 4, 3C 4A, and 5A of the agreement.
Would you agree that the position of DEO is contrary to your testimony today?
Yes.
Now, one last thing. Let me show you an email and ask if you recognize that.
Yes, I do.
And what do you recognize it as being?
This was a response to me from Anna Richmond following a meeting that I had with Anna and with Bill Killingsworth addressing certain issues with respect to Sandestin DRI.
And were you seeking DEO's position on certain matters that had been contained in their May 30th letter?
Yeah, I thought that they ought to clarify a couple of points.
Okay, and the first point, could you read that into the record, the first question you posed, which is number 1?
Well, this doesn't reflect my question, it's their answer.
Their answer.
Ancillary space. The department's letter states that the Sandestin DRI development order does not reference or define the term ancillary space. The lack of a definition in the development order does not preclude the county from amending the development order to define the terms and applying it to future development orders. That's the first one.
And your testimony a little bit ago about ancillary space and that had been done in the past, in fact, are you aware whether the developer has ever applied to have that categorized as ancillary space?
Your question assumes that it takes an amendment. to do that.
You think a developer can do that unilaterally?
I think the county has established an interpretation that they've used consistently up until a certain point at which they decided they wouldn't use it anymore.
And would you agree that would be a reclassification of the land use?
No, I would agree that that's an estoppel issue.
Stop?
That's right.
Stop.
That's right.
Let me have you then read the second question.
The land use changes. The department was asked by the county if land use changes could be made to the DRI in an annual report unless the developer order expressly allows land use changes without an amendment to the development order. All land use changes must be made pursuant to an amendment to the development order under Section 380-0619 Florida statutes. No land use changes can be made in a DRI, annual, or biennial report.
The changes in use that we talked about this morning, did the developer seek those through an amendment of the development order?
I don't think the developer filed an OPC.
We would like to introduce the email as our next exhibit, which I think is FF.
That's correct. Mr. Chairman, recommended acceptance.
We'll accept it.
Thank you, Mr. Metcalf. I have nothing further.
Any other questions? Thank you, Mr. Metcalf.
Thank you.
Just so you know, that's about 10 minutes.
One last thing. I'm sorry, I apologize, Dan. The reference that we had to Mr. Beck's letter, I would also like to introduce that letter as GG for the staff.
Which one was it?
That's the June 12th letter, June 7th letter to Ms. Craig by Tom Beck.
I see it. Hold on one second.
Mr. Beck knows a copy, I believe.
Just hold on.
Would this be GG or GG?
We accept it in.
And Mr. Chairman, just for the record, I want to make note how much time is being eaten up on cross-examination.
Understood.
All right.
Who's next?
Mr. Boss. No.
Mr. Boss, please state your name for the record.
Peter Boss. I think I have the distinction of being the oldest person up here. Dealing with Sandestin. I actually started working on it now.
Hold on, excuse me. I have one of 4 commissioners who's not here, and I've got an important witness, so I'd rather wait till that commissioner comes back.
We'll hang on.
We'll stand by just a minute.
Mr. Boss, were you sworn? Mr. Boss, were you sworn earlier? I didn't remember seeing you.
I don't know, but I will.
Okay. Do you solemnly swear or affirm the testimony you would give before this board will be the truth?
I do.
Thank you.
Is there a source of water, bottled water anywhere?
We'll get you.
You want to take a break? Yeah. Mr. Chairman, can we take a break then, just 5-minute break for everybody?
All right, let's just go ahead and take a 5-minute.
I find it very interesting.
You don't believe I'll keep up with them.
Come to order, please. Come to order, please. Okay, Mr. Boss, I think you have the floor, sir.
Thank you, Mr. Chairman. My involvement in Sandestin actually goes back 42 years. My first involvement came here. Actually, I competed with the Evans and Mitchell Company to buy the property originally, having a dream of a master plan community that's right on the beach. And my business was basically building large projects. Some of you may know Inverness and Birmingham, Stonebridge, Memphis, Bay Meadows, Jacksonville, and there's 6 other ones across the nation. But this piece of property was unique because of the harbor and having the beach and a natural harbor. And frankly, I was extremely disappointed when Evans and Mitchell had tied up the key piece of property. My next involvement came in 1976 when I was hired by two companies, Cabot and Forbes and Chase Bank. They were the successors. They basically were the creditors on this property, and they'd taken it back in bankruptcy when the stay was lifted. And they consulted with me relative to the DRI. The DRI at that point hadn't been processed. It hadn't started. The DRI whole law was new. It was embryonic. We were starting in the early 70s. So not only was the state going through some growing pains about the DRIs, everybody was. And for those of you who were not in Walton County in that date in 1976, it was extremely rural. The deed that I was presented in 1972 labeled Sandestin as worthless property in bold letters all the way across it. And the reason was you couldn't grow anything on it. So we've evolved. Earlier you heard a speaker say that in 1976 there had been a hurricane through. There had been all kinds of disruptions in '76. Kevin Forbes, my job was to ask me for advice. I advised them to proceed and get the DRI process because it became the baseline, the establishment of what was going to be a very large community. If it was going to work, it had to avoid being subject to changing codes, changing programs, and so forth, which would typically evolve in the evolution of a community as it grew from a rural, totally undeveloped area into what I saw as a combination of tourism and retirement area. My next opportunity came in 1978 when I actually met a fellow named Ego von Bohemen. I had heard through Chase Bank that the Chase component had been purchased by his company. He's a Dutchman. I'm a Dutchman. That helped. And we made friends quickly, and I became his partner, taking over operations for the project in early 1979. At that point, we had a DRI in place, but we had a project that was completely bifurcated. It was in multiple pieces, and my basic target was to try and reassemble the property, at the same time get some development going. Mr. Bohemen found it was very difficult to obtain credit in the U.S., and we were unable to raise the dollars to acquire the property, and I ultimately bought Mr. Bohemen out. And in early 1981, I became the sole owner of Sandestin and proceeded to acquire the remaining 900 and some acres and reassemble what was originally, with the exception of the north tip, which has been referred to here, the last 440 acres, which ultimately I did not get until 1983. In 1984, we basically, at that point, had reassembled the entire DRI, and every day of my life, from the time I mentioned it in 1976 to that date, I recognized the importance of the vesting rights that go with that DRI. There's been a lot of discussion about the 74 letter and benchmarks and so forth. I think I can add a lot of clarity to that. I was there. I was part of the discussion. The DCA and the government groups were basically trying to sort out what was and what wasn't. There was not a great planning staff, not great in quality of people, but not great in quantity of people in Walton County at that time. It was very rural. We had our own we started the fire department. We started the cable TV company. We started the phone companies. There were just literally very few services available in the South Walton County area and, frankly, in Walton County at that point. Just months before the acquisition in '79, they started the building department. So it was just all coming together. But what's been referenced, the 84, was basically just trying to take everything, the old plan from the DRI, which is what we were operating under, the 76 DRI, and just look at it with a new plan, because we developed a new plan. We didn't like the plan of Evans and Mitchell, and we did variations to that plan. And in a DRI, a project that has, in this case, 40-year life, plans change a lot. It's an ever-evolving process. And unlike most of the county, if you look at most land, you'll see them in square pieces. They're sold off in rectangles or squares. or chunks, and then the developer fills in the spaces, and you allocate so much to green space, so much for this. Parking lots just fit. You work with setbacks. If you look at the Sandestin master plan, you won't find a single square piece of property. You design the building, and you basically design the property line around it and the roads that get to it and a sense of arrival and the views, et cetera, et cetera. So unlike a project of a whole lot of a grid of buildings, shall we say, or tracts, small tracts, when you start dealing with a 2,450-acre tract of land on a clean slate, you put the roads where you want them. You put the buildings where you want them. You elevate roads where you want them. You put views where you want them, and you create open space where you want it. Open space is not, and that's one of the topics of the discussion, open space is not just a question. If you took 600 acres or whatever number of acres, you blocked it out and say, okay, that's a lawn and it's open space. That doesn't create a lifestyle image. That doesn't create a quality development. Why is Sandestin recognized worldwide as one of the best beach resorts in the whole world? I like to take some credit for that. It's the master plan. It's the attention to detail. It's the intersection of every road has an opening. You don't have a house. If you go to Indian Bayou, every time you go to an intersection, there's a house there because they could sell a lot on a golf course. You can't even tell it's a golf course. You go to Sandestin, you'll never see that. You're always exposed. So whether you're on the golf course or not, you're always part of a golf course community. Every chance you can, you get exposure to water. Every chance possible, you get exposure to lakes. So what is open space? Open space is taking the houses and setting them back extra far from a golf course so the fairway looks better. So you get a more open space. The lot may be in, but you make the house set back further so it appears more open space. It's a combination of roads making the turn and creating a little more green space between you and the lake. It's a whole series of little pieces all added together which don't really materialize, but they aggregate through the whole development process. And what you get done is something of civic pride, because when you drive through Sandestin, it's not like any other project anywhere. It's one of the best there is. And this is a sad day. I sit here and I listen to this, and I hear all this negatives and picking apart little pieces of land and saying, that's not an open space, and that is an open space. Open space are senses of the development and what you feel like when you drive through a property. And when you pull up and you're heading to Baytown and your road intersects and you get that beautiful expansive view across those fairways, those could have all been lots. The water's there, the sewer's there, everything's there. But they're not lots. And why aren't they lots? They're not lots so you get these great senses of open space. So Sandestin is a very special project. It's dear to my heart. I'm sorry that I lost it. I lost it because I had to sell it, because we had a financial crisis. But even when I sold it, I made the developer who bought it guarantee to keep it together and live to the master plan. And what is the master plan? The master plan is really three hubs, shall we say. You've got a beach hub, and you've got a convention hub, which is on Bayside, which is the grandfathered area. I'm not sure what the right terminology is. Then you have everything around the Grand Sandestin or the marina. As you pull away from that, you go to more residential. You get further away from that commercial hub. The further you go to Burnt Pine, nicer and nicer houses. And the farther end point would be our private country club, which is the Burnt Pine area. And that's a gated community within a gated community. Those things are real important to me. I could have kept pieces of Sandestin and then I would have broken it apart. But what makes Sandestin so special is it's a 2,400-acre horizontal residential hotel where all the services are available and everything's there with one-stop shopping. I never, ever would give up any rights to that 1976 DRI that I spent and sold everything I owned to make sure that I preserved and to put that land together again. It never would have happened. And when they talk about a baseline, to me, what that meant to me was, because we finally had a plan, that a baseline to me is a line. And each year, because we have to have something to reference to, we could do more of this or less of this, but basically it was to show as the project evolved, and the variance gets less and less, because over time, all of a sudden, it's all gone. And when it's gone, and what's not used is not used. But until you get there, you have a baseline to look at. And the reason is that everybody trying to figure out from all these old plans, and the plans were pretty sketchy, they needed a good drawing, a line, a baseline to look at. We agree. But that doesn't mean that becomes a new number. It just means that some things are going to exceed and some things are going to be less than. And every time you do a phase, every time you lock onto a piece, that's a piece of property you can't develop any longer. So the project is gradually shrinking in its ability to vary. But in the beginning, it was all variable. It had planned for 30,000 people. And the restrictions where the worry was how many people are going to enter from the south and hit the road impact, and how many are going to enter from the north. But once you're inside of it, it was really a question of it's like building a new town, a well-planned town. When there was no planning staff and there was no city, every county having to turn in a plan. We were so far ahead of all that, and the county commission at the time said, Peter, we can't plan it better than that. That's you plan it, and you live with all the requirements and the state requirements and life safety requirements. You plan it. You can't have any more than this, and that was the quantity. And then we varied from that, and we went forward with that. In the project, I think, and I can't imagine anyone in this room not being proud that is the project of this county. It's your number. No, I'm done. Sorry. It's sad that this is happening, because this is the evolution of a DRI and why you do a DRI to get it so you can finish it and build it out. And not everybody's happy. Not everyone's ever going to be happy on anything, no matter what it is. But it's a great property, and I'm proud that I was part of it. You should be proud that it's in this county.
Okay, thank you, Mr. Boss. Who's next?
Mr. Burgess.
If you will, state your name for the record.
Good afternoon. My name is Dean Burgess. I'm with Emerald Coast Associates. My part of the presentation will address open space methodology for calculation of open space and the residential question about residential acreage. And I'm going to make sure that I got all the buttons right on this.
Top button.
It's not advancing. That's
Can somebody sit there? She does.
First part of my presentation, when talking about open space, the first thing we need to do is define what is open space. The EPA has a definition of open space being any piece of land that is undeveloped, has no buildings or built structures, that is accessible to the public. This could arguably preclude all of Sandestin because it is a private resort and it's not open to the general public. Another definition is straight out of the Walton County Land Development Code. It defines open space as the amount of the site that is devoted to recreation, resource protection, amenity, and/or landscape buffers. Open space may include, but is not limited to, lawns, decorative planting, walkways, active and passive recreation areas, playgrounds, fountains, swimming pools, wooded areas, and water courses. This definition arguably goes beyond what may be anticipated for Sandestin. My point being, open space needs to be evaluated in the context by which it was reviewed and approved at the time it was reviewed and approved, i.e. the 1976 development order. So let's take a look at what the 1976 development order says about open space. And I'm going to go to these exhibits and read to you what the text said, because I'm going to want you to look at the exhibits as we go. The original 1974 ADA documents outlined 604.9 acres of open space. And I would assert to you, if you look at the values highlighted in pink, there's 540 for the north side, plus 16.9, plus 17.3, plus 30.7. It tallies up to 604.9 acres of open space. Now, if we wanted to try to keep consistency, and we'll get into the 1984 agreement down the road, but understanding that the 1984 introduced right-of-ways into open space, that number goes up to 700.9 acres, inclusive of right-of-ways and the power line easement. Next exhibit that I show addresses the 1984 non-substantial deviation that Mr. Metcalf discussed and Mr. Voss elaborated on as well. Those documents conceptually outline 954.8 acres of open space, and that number is highlighted, though difficult to read in the documents here. Now, it's important to note that, as Mr. Metcalf mentioned, the 1984 documents is where things started to go awry. We can see a part of that unraveling right here in the very first document that they submitted. At the bottom, they left out their totals here, and the left-hand column does not add up to their total acreage of what they claim is their acreage of the total resort. It totals up to 1,941.9, and they say it was 1,960. So we've already got some discrepancies in numbers and tabulation, which, by the way, is what prompted us to go to all this effort of establishing the parcel-by-parcel maps that are now in the annual report. There was a question, whenever there was a dispute or a discrepancy with acreage, you had to literally recalculate the whole DRI to try to figure out where your discrepancy fell. With the parcel maps, you can go to an individual parcel, and if somebody has a question or a dispute about that, each parcel is totaled up. What's open space? What's residential? What's non-residential? All of those values are on the smallest element of the DRI, which is the parcel. And it can easily and expeditiously help out with the accounting work. This is just the south side total that is added in to provide that 954.8, which staff has also presented to you today, and there's no dispute on that number. Lastly, the supplemental 1985 documents that came after this 1984 agreement was signed stipulated, as staff has stated, 1,031 acres of open space. So again, we have 3 open space numbers that are before you. The 1974 ADA documents, which I also believe are the baseline and the foundation by which this DRI should be judged. The 1984 non-substantial deviation agreement that came about with DCA, or with DCA at the time, and then the supplemental 85 documents that nobody really knew what they were going to say until at the time of the 84 agreement, because they weren't available yet. My point being that we have 3 prospective values to evaluate for open space. The original ADA continues to establish the substantial deviation threshold for open space, since no substantial deviation has occurred during the life of the DRI. Note that a substantial deviation is the only way to change thresholds that control future substantial deviations. In other words, that's my support to why the 84 documents do not control. There was not a substantial deviation that was actually found by Walton County in the 1984 non-substantial deviation development order. Nonetheless, the amount of open space provided exceeds all of the values above, and I will demonstrate that. There's 1,183.28 acres of open space provided in the DRI at this time. Lastly, Section 20, parentheses B9 of the 1974 ADA documents states that the development plan will follow the cell theory in which each pocket or parcel will have its own recreational and amenity offerings. The significance of this statement is that, and the reason it's important is because it supports and recognizes the concept of open space allocation within the individual development parcels, as Mr. Boss had also mentioned to you in his discussion. All right. So where are the discrepancies with staff's evaluation of open space? And I'd like to very simply go to that. You've probably already seen that. It's in your staff report. The three highlighted numbers, green space, nature preserve, and major road right-of-way are the three areas that they've pointed out that they take issue with how we've calculated open space. Staff has not acknowledged 110.24 acres of green space. 65.8 acres of this is the golf course and lake buffers that they described to you, and I will also describe in more detail. Another 44.44 acres of green space has not been acknowledged by staff, and they have not identified where that disputed 44.44 acres is. I assume it's in these common area, platted common areas that we have identified as open space. The other two, nature preserve and major road right-of-way, I'll also describe in detail what our methodology was for each of those. Let's start with the golf course and lake buffers and common area open space. And again, I'll go ahead and go to the exhibits, and I will, what I'm talking from is directly the text that was up there. We've got a larger version of the master plan if you need it, but the first thing I'd like to refer to is, if it's easier for any of you all to look at this, you're welcome to pass it around. This is a large version of exactly what's up there. It may be easier for me just to hold it.
Just sit it right there. Yeah.
Sure. That's all right.
That's good.
All right.
Can't see the commissioners.
The importance of that 84 document is it was the master plan that first identifies with clarity these areas around all of the golf holes and around all the lakes. You see this this type pattern of hatching. If you look at the legend, that is green space and buffers. And around each golf hole, you see it, and around each lake, you see it. There's a strip that's intended to buffer the lakes and golf courses from the residential communities. In keeping with that, our methodology was to go ahead and look at all the residential plats, because we did not observe these buffers in the past, and we reviewed the covenants and restrictions and the plats themselves and determined where those buffers are and if they occurred in the covenants and restrictions and in the plats. And in nearly every case, there were 39 parcels that were identified on those golf courses that did indeed have those buffers identified. This is an example that I've taken on parcel 127. This is our amended map showing the green space around the perimeter of the lake. This is the actual aerial photograph, and you can see the backs of these units remain in open space. Back here, it's a small sliver, but again, on our diagram, it was illustrated as a small sliver where it's small, and a large sliver where it's larger. The covenants and restrictions designated all common area to be used as golf course. We only took the rears of the buildings. Lake and golf course buffers are enforceable by the Architectural Review Board and Sandestin Owners Association, as both of these groups must review every building permit that's processed through Sandestin. A copy of all parcel maps can be furnished to the ARB and SOA specifically to assure that these areas are maintained. Further, SDI must first authorize any encroachments into these buffers. So that gives us a monitoring and security mechanism to make sure that these areas are maintained. Similarly, the platted common areas in residential subdivisions and condominiums cannot be altered or developed from their intended platted purpose. And the reason that I bring that up is here's an example of one of those platted common areas right here in the middle of this parcel, which is 439. And here you can see the common area there, again, maintained in open space. The next issue that staff took with our evaluation was the nature preserve on parcel 340. I believe Mr. Stewart pointed this out to you as well. And what we found whenever we looked at that was this area here that agreeably was claimed in our annual report as open space. Actually, when Sandestin was first formed, there were 3 existing houses that are there. We've acknowledged that. That 7.1 acres we will reduce. You will see that there is still a wetland area here that we will obviously want to keep and claim as open space. Roughly, I believe that will reduce our open space about 3.5 acres, and we agree with staff's evaluation about that, and that's another good example of how these parcel maps are so helpful. Something like this gets seen. In the past, without these parcel maps, we'd have to go through the whole open space, the whole green space evaluation to try to figure out, did we or did we not include that in open space? You can go right to the parcel map and see, yeah, we did, fine, we'll reduce it. Last issue with open space that county staff took with our evaluation was determination of major road right-of-way. And actually, during staff's presentation, I have to take issue with a word that kept getting utilized in the course of their discussion, that there was a unilateral decision made by this group whenever we did our annual reports and formulated our annual reports. And there really could have been nothing further. There's nothing further from the truth. We met for 4 years with staff in an effort to define what our reporting limits would be. Everybody agreed we've got to change how things are being reported in Sandestin because of all the obvious errors that occurred in 2002, 2004, subsequent NOPCs. It was difficult to track, and the tables didn't add up. There was a litany of math errors and so forth. So it was a long, drawn-out process to try to determine how we can better present our facts and figures for the DRI. And those efforts went on for a period of 4 years. I joined those efforts in the latter 2 years, and can personally, attest that it was an effort to be in concert with staff before we came to this board with an NOPC or any discussion of the resort. We obviously wanted to be on the same page with our methodology and what we were saying. Unfortunately, that hasn't happened, or perhaps this meeting's just predates our ability to do that. Moving on, in order to determine a major right-of-way, first thing we need to do is define what is a major right-of-way. The 1984 map and supplemental 85 materials are functionally most consistent with the FDOT definition of collector roads and a local street system. A local street system is defined as the group of roads having land access as their primary purpose, typically within a portion of a county or urban area. Although providing the largest portion of road miles, this system contributes little to highway travel due to short trip lengths and low volumes. The staff report argues that the intent of the documents was only to include collector roads. Collector roads are defined as a group of roads providing a mix of mobility and land access functions, typically within a given county or urban area, linking major land uses to each other or the arterial highway system. The collector road system is composed of rural major collectors, rural minor collectors, and urban collectors. Differentiation between major and minor classes are not made in urban areas, such as we have with Sandestin. This is a map that actually the 84 map that you had in front of you illustrates roads that clearly are lower order roads. I think most of us are familiar with Buck Road, Shipwreck Road, Sandestin Lane, Beach Walk Drive, West Winds Drive. There was one that was a school road that just went into the proposed school, and Heron Walk Drive. All of those are, by either a layperson's or professional's opinion, are clearly local roads. They provide direct access to the land and even subdivision of land, the individual lots. So clearly the intent of the 1984 map and the road designation system included local roads. Working with staff to current staff report regarding road right-of-way methodology. What we did during this part of this 4-year discussion with staff was to discuss open space within road right-of-ways on the 1984 plan. The 1984 master plan clearly identifies major roads. Discussions were held regarding whether it was appropriate to only count the pervious areas of the right-of-way toward open space. I think Mr. Stewart touched on this briefly. In 2012, staff had the GIS department conduct an evaluation of right-of-ways within Sandestin. 147.42 acres of right-of-way were identified, and a resulting 88.98 acres of eligible open space was identified based upon pervious area within those right-of-ways. This map illustrates the roads, and it's a bit difficult to see, but all of these that are in this purple color were identified by staff, and that was part of the calculation that goes down south to these roads here. The point is, there was 147.42 acres of right-of-way that was identified. At the time, we were considering whether we do or don't take half of those right-of-ways. If we did take half of those right-of-ways, we would end up with 88.98 acres of open space. Subsequent to receiving this information, my company digitized the 1984 master plan, as seen here. And this is turned 90 degrees, north is to the left. And we calculated the total right-of-way area of the roads identified as major roads in the 1984 master plan. The resulting total measured right-of-way was 80.71 acres, compared to a reported major right-of-way open space in the 85 supplemental documents of 76. This exercise demonstrated that the 1984 documents intended for the entire right-of-way to be counted toward open space, and staff has agreed with this determination. However, what they've done, they've completely ignored the fact that at one time they were in concert with us to include 147 acres of right-of-way as appropriate and reasonable roads to include in our open space calculation. It would follow logic based on the above account that staff would agree to at least 147.42 acres of right-of-way, and that it would be attributed toward open space as calculated by their GIS department. How or why staff is now only claiming 86.66 acres of right-of-way toward open space has not been explained. It appears that the criteria utilized to identify what staff is willing to accept as major right-of-ways is, at the very least, inconsistent. The next topic is the explanation of residential acreage reporting. And I think this is a very simple question about math and calculations of the right-of-way. I'm going to see if I can zoom in on this a bit. This is straight out of the staff report. And they have a total number of acres given here. The open space acres, residential acres, and non-residential acres. You'll note in staff's presentation they only showed the total and residential acres. I think the reason for that is if you take these three numbers here and add them up, they don't add up to 2,062.86 acres. They add up to something quite a bit more than that. They add up to 2,211.8 acres, the difference being 148.92 acres. The significance of that number is that is exactly what we have claimed in road right-of-way open space. Our road right-of-way open space is 148.92 acres. And the reason being simply that the residential acreage of, I believe that's 1,009.5, includes those road right-of-ways, as does the open space number also. So the road right-of-way open space has been counted twice. It is appropriate to include it in open space. It's not appropriate to include it again in the residential area. The table on this page also does not include the 65.8 acres of open space that we've designated for lake and golf course buffers, which I just went through with you a few slides ago. The result of the above two items is a residential total of 794.78 acres, which is considerably less than the 825.1 in 1984, and a lot less than the roughly, I think it was 1,103 acres in 1976 that was dedicated to residential acreage. So I think that explains what happened with residential acreage. It's not, we haven't added residential acreage anywhere in the resort. Next item I'd like to discuss is our response to the report provided by Ms. Gray regarding open space. And I think that's most easily done in her own table. On table 1 of page 3 of Ms. Gray's report, it gave no credit to this 220.64 acres, which she acknowledged in her presentation, for green space. It appears that Ms. Gray has not counted this open space because the term used in the 1984 documents is green belts rather than green space. A multitude of terms have been used to categorize open space in the ADA documents and in the subsequent 1985 supplemental documents to the 1984 non-substantial deviation determination. A change in terminology simply does not constitute a substantial compliance concern. If it's the wishes of this board for us to change the name of that space to green belts, we'd be more than happy to do it. It's a simple matter of semantics. Conclusions. The 1974 ADA documents continue to establish the thresholds for development rights of the Sandestin DRI, since no substantial deviation to the original development order has ever occurred. SDI has demonstrated that currently a total of 1,183.28 acres of open space are accounted for in the Sandestin DRI. This exceeds the 1974 ADA document value of 604.9, the 1984 non-substantial deviation master plan value of 954.8 acres, and the 1985 supplemental documents to that 84 non-substantial deviation value, which was 1,031.1 acres. When road right-of-ways are properly allocated to open space, the resulting residential acreage of the resort is 794.78 acres, which is less than the 1984 value of 825.5 acres, and well below the 74 ADA values of 1103.4. I remembered that number pretty well, I guess. The use of the term green space instead of green belt does not constitute a new open space category. That's with regard to Ms. Gray's comment. In summary, the development is in compliance with existing open space requirements and well within the 1974 vested development rights of the DRI. Residential acreage is also below acreage requirements and well below the 74 vested development rights of the DRI. I'd be happy to take any questions. Hopefully this has offered some answers to your questions.
Is there any questions?
I just have a comment on the your characterization of working with staff. And I've been back on the commission for a year and a half, and I've worked with staff on a number of things. I think your characterization of staff is incorrect. I think staff has basically been over backwards to work with y'all on your definition of open space, even probably against some of their better judgment at times. But I think that even if they've been over backwards, you still don't meet the open space requirements that appear to be the guiding principles for the DRI. So I would say that I would characterize it more as back and forth pressure between, because I saw some of the memorandum of understanding that came out, but I'd say it's more back and forth pressure on staff to accept what y'all were putting forward as open space rather than working congenially with staff on, coming up with open space. That would be my characterization of it.
I believe we've accurately applied the 1976 ADA documents and what they stated to what we claimed as open space.
So wouldn't that mean that there's a golf course, there should be a golf course in Driftwood if you're claiming the 76 documents rule?
I didn't say that the documents were maintained. That went through an NOPC process. The development order was also reviewed by county staff, and we were not involved in any part of that. This developer was not involved.
The minor development. But if you go back to the 76 plan, you go back to the 76 plan, would be my opinion. And so 76 plan said golf course. So you got some problems.
I believe staff has a problem with that. It shouldn't have been approved.
Okay. Any other comments, questions? Mr. Stewart, if you come forward, please.
Mr. Stewart, come here. See. Oh, he's got them. Oh, okay.
Mr. Burgess, just a couple questions. First of all, in terms of the definition or the characterization of the roadways that were included in the supplemental material as part of the 84-85 agreement, how are they characterized in that supplemental material?
On the map, they were called major roadways on the 84 map.
But let's talk about the material that was submitted as supplement to DCA as to the 84 agreement.
Are you referring to the Exhibit 6?
Whatever that exhibit is.
Okay. There was an exhibit called Exhibit 6 that was a table in 1985, and that classified them as major collection roads, not major collector. As far as what that means, I think it's better defined by looking at the map to see what it meant.
So in your analysis,
it included the roads that I mentioned to you, which are clearly local roads.
and in your analysis, you have rejected that characterization as to, in the supplemental documents, and you have basically came up with your own standard, looking at the roads.
I have not rejected. I just don't think major collection roads is not a term used by DOT or traffic engineers. Major collector roads are. I believe the road system in Sandestin, even the larger loop roads are. It's a stretch to call them a collector road. They're all local roads. They all function to access land and lots within the resort.
Is there any
The-
roads that you rejected in your analysis for open space?
We did not include service drives, roads that are not open to the general public, and I think that's a distinction that was trying to be made. Is a service drive, a parking lot access is not a major road. It's not used by the general public.
Would you agree that the standard that you were attempting to apply was the standard that was contained in the 1984 as supplemented agreement?
Yes, sir.
And as Mr. Metcalf, if you don't think that agreement applies, why did you submit those roads?
Because we were trying to report in the format of those documents. It's our understanding that those documents did outline a reporting format, and that format also does outline a category for major right-of-ways and for power line easement. So we included those.
So is it your testimony that you are taking some of the material from the 84, 85, but in terms of obligations and future responsibilities, you say the 76 development order applies?
No, sir.
Okay. What are
I think
saying?
because there was never a substantial deviation to the development order, and my understanding is that the only way to change a DRI is to go through a substantial deviation. That was never done, so our initial vested rights from 1976 still apply. That's why I made it a point to identify if you apply the 84 reporting requirements for open space and utilize right-of-ways, it would be 700.9 acres, which includes right-of-ways, instead of the 604.9 acres, which does not include right-of-ways.
The adding of the golf course and water buffers, the adding of these additional roads, which were not included in 84, 85, who's the entity that has authority to make the decision whether they can be counted for open space?
Well, that's ultimately would be through the county if it comes through the NOPC process.
And why wasn't one filed?
I don't know.
Now,
now let me clarify that. Those changes occurred prior to myself being involved in the DRI or SDI.
Now, the annual reports SDI has been involved in, has it not?
That's correct, but those changes...
And in fact, those additional materials were included in that annual report. Did they ever, to your knowledge, make any effort to submit those to this board to get approval for considering them as open space?
No, sir. I was referring to the addition of the actual roadways themselves.
You talk about the variances of the golf course buffer and that Sandestin has the authority to approve those intrusions and those buffers.
Yes, sir.
Do you know whether they've approved incursions into those buffers?
I have identified in a few limited cases where that has occurred. We would be more than willing to remove those areas from our calculation. I've superimposed all 39 parcels. I've superimposed aerials over each.
In fact, there's quite a few, are there not?
I believe there were 6 that I identified.
And in fact, in terms of the Architectural Review Board, didn't they just improve one in January of this year, these minutes?
I don't know.
Do you know if Sandestin was consulted and gave their consent before the Architectural Review Board approved the intrusion into the golf course setback?
I don't know whether they were or not.
Now, who did the road calculation on the math there? Who actually did that calculation?
My company. It was my CAD technician, my company.
And we talked about the roads. Buck Road, is Buck Road in the DRI?
Buck Road, as far as I know, is not in the DRI, but it was shown on that 84 map.
Okay, and that's still counted then?
It was counted in, to the best of my knowledge, it was included in those calculations.
And Mac Bayou Road, is that also counted?
No, sir.
It's not counted?
No.
That's not in the DRI?
That's not in the DRI.
Thank you, sir.
Sure.
Thank you. Who's next? You've been sworn, haven't you? Yes, sir. If you state your name for the record.
Good afternoon.
Hang on a minute, please. We're going to halt just for a minute, allow the commissioner to do what she needs to do.
You know how that feels?
Okay, we'll start over. Just state your name for the record, please.
Okay. Let me pull this up real quick. Okay. My name is Keith Danton. I'm a professional licensed engineer in the state of Florida, Vice President of Danton Consulting. I reside at 506 Frank Shaw Road, Tallahassee, Florida. Before I kind of get into the presentation.
Mr. Danton, you were sworn. You were sworn.
Yes, I was. Before I kind of get into the presentation of kind of analyzing, refuting some of the things that are here today, I just want to kind of go through some of the things that I've heard from various people today. Although I was having fun in this area back in 1976, I wasn't involved in the actual 1976 master plan. And to possibly say, as the county contends, what the intentions were, I find that a little difficult. However, I've been reviewing all the DRI documents since I was brought on board by IntraWest and Mr. Becknell back in late 2008, 2009, until today. And I can say unequivocally that the county has approved all past applications and that the 76 DO vested rights prevail and that this development was allowed the flexibility and a fluid, dynamic application of what you see today. And that's imperative with any DRI. But what you see today as it relates to where the county wants to be is to create a very static and restrictive development based on a past master plan, which I like to call a cartoon because that's all it is, way back in its conception. And they cannot accurately substantiate the acreages that were intended or applied back in that cartoon back in 76 or in 84. Since I've been involved, I was involved with a collaborative effort with the county, with Ms. Renee Bradley and Ms. Pat Blackshear back in 2009 to try and create for the first time a parcel by parcel jigsaw puzzle of the master plan. And I thought it imperative at that time, hiring Jacobs Engineer, who was doing the work for IntraWest and continued doing work for Mr. Becknell after he bought the property, not only to create a spreadsheet of all of these different parcels, but to also validate it in a map-by-map, parcel-by-parcel designation. And this map-by-map parcel designation was directed not only in content, but in methodology by the county and IntraWest to figure out what was platted, what was not platted, what was green space, what was lakes, what was roads. It was a collaborative effort between all parties, and I was involved in those parts. And the importance of that is that we were trying to come to the board, and I've been an engineer a long time, and I've worked on many master plans and many DRIs, is to come before the board with a potential NOPC that staff and the developer agrees upon, not to be in conflict, but in agreement. And that was the intent of where we were for many years. And in that effort, they tried to look at all the roads and break them up into half, which was not in any category or anything that was done in past, but that was believed that let's do this together because it kind of makes a little bit of sense. They also instructed us to analyze every building that was built and to use the same standard that was applied to the Grand Boulevard allowance and remove the ancillary square footage from the entitlement takedown. That's what we did in an effort with the county, at the staff at that time, and submitted those results in the 2011 and 2012 annual report. Staff changed after that, and those allowances and that agreement basically was disallowed, a change of direction. So then we decided a new approach. Let's meet with the new staff and figure out a new methodology. We met with Renee and Wayne Dice and others of new staff that were there. And we tried to create a new memo of understanding that was basically taking into effect different methodologies as it relates to land use, categories, ancillary building again, and so forth. And we supplied those results in the revised 2012 annual report back in October of 2012, and again in 2013. But I think what's interesting to comment on is I keep hearing that Sandestin is overbuilt. That's completely wrong. Sandestin is not overbuilt. There's over 1,800 residential development units left, and the county does not disagree with that number. The county contends that we've overbuilt by over 100,000 square feet of commercial development, yet they maintain on the second breath that there's over 150,000 square feet of non-residential entitlements that remain. So how can we be overbuilt? So now I'm going to get into the presentation. I think it's important to understand, and I'm not going to argue the validity of the various annual reports, because as I've said over the years, they've changed directions. But I am going to go into a new analysis that I've conducted based on where I believe we should be. The 1974 ADA, which is the application and approved in 76, stated that non-residential, and that's what I'm here to talk about mainly, is the non-residential accusations of noncompliance that's been thrust upon SDI. Non-residential commercial back in the 70s was described as an integral part of other facilities, and this mixed-use concept will increase the resort ambience and reduce both internal and external traffic circulation. It's important. The 1974 ADA, Section F, Other Impacts, Pocket Uses, listed 156.7 acres as set aside via other non-residential use. No square footage was ever used, simply acres. The 1984 development order, again, listed 148 acres of residential, non-residential square foot, a decrease from the previous 76, but later reported in the 84 agreement that 87,100 square feet was actually built and placed in placeholders within the development. Not restrictive, but simply placeholders. The 1984 DCA agreement, non-residential square foot, then became built to date plus proposed for a total of 846,700 square feet, and again was put in placeholders for future reporting. The 2004 NOPC, last approved NOPC, the total non-residential square footage granted and allowed is 1,021,895 square feet. Since 2004, again, Sandestin, myself, have been working with the county at their direction. Let's talk about ancillary definitions as it relates to non-residential use. DCA provided ancillary definition as a use of land or of a building or a portion thereof customarily incidental and subordinate to the principal use of the land or building and located on the same lot with the principal use. The building ancillary definition that we thought we had an agreement with the county in the Memorandum of Understanding and prior to that, as it relates to the Grand Boulevard, was that the calculations of net square feet for purposes of entitlement takedown will only be areas under roof, and air-conditioned space shall be included, excluding porches and patios. However, common areas that do not individually or collectively create off-site impacts, such as HVA rooms, bathrooms, storage areas, inclusive of warehouses, stairwells, shall be excluded and deemed ancillary use. Consideration will also be given towards what the county previously approved for the Grand Boulevard should be determined to exceed the conditions stipulated above. This ancillary determination will be used for past and present non-residential entitlement reconciliations. We weren't asking for anything more than what the Grand Boulevard was granted. Grand Boulevard was granted this in an existing DO, and they were grandfathered in for what they had already built. as it relates to ancillary takedown as it relates to this definition. Further, we went, all buildings were analyzed, traffic back analyzed provided, and based on the above direction by the county, based upon this past direction, I analyzed everything again per the DEO 2012 direction, was kind of let's categorize everything per the 84 agreement. Now, I created a cohesive and accurate assessment of the non-residential square foot built, and based on these conditions, Sandestin has built and are committed, and when I say committed, that would be the Grand Boulevard since it was sold, 848,676 square feet of non-residential use and has a minimum of 173,219 square foot remaining. I say, let's see Exhibit A. So Exhibit A is basically the computations. It's hard to read, but here are the categories per the 84 agreement. Here's 74 placed in those same categories, all in acreage. Here's 84 development order, their acreage also placed, and their proposed and already constructed acreage placed in those same categories. Here's the 84 agreement placed accordingly. And here's where we are today, also placed categorically in the same, compared all the way through. 158 acres, 148 acres. Then we started getting really away from acres other than just a reporting. We really started getting into strictly square feet built. The yellow represents the buildings that we basically applied the ancillary use to. And of that amount, it is approximately 17,400 square feet of ancillary that we're proposing. If you subtract that basically from these numbers, it's roughly about 4,000 square feet in the area of what the county says we do have remaining. So the real difference is this ancillary determination. The bottom here basically shows how we got to 1,021,895 square feet of non-residential entitlements. We started with so many in 84, so much was added in two, I think it was the 1998 NOPC, the 2002 NOPC, which added 175,155 square feet to get to this total. Now, to take it a little bit further, I think that's at a minimum what this developer has to build that he has left. I contend that certain land uses such as the Baytown Raven Clubhouse, the marina, the beach tennis club, and the well house are ancillary land uses that do not generate additional traffic of regional impact out on the roads that are out there today. They're ancillary and supportive of the entire development. People are already there using these developments. So I believe it is a maximum in concert with the ancillary allowances that the developer has up to 209,034 square feet of commercial, non-residential commercial remaining. The county has agreed over the years on the methodologies for ground truthing within the spirit of the DRI intent and the history of the Sandestin NOPCs only to change their minds once we have submitted the summary of these results. And it's not so much that they've changed their mind, it's been a different direction with different administration and different over the years since we've been doing this since 2008. Walton County and Sandestin, the out-of-compliance analysis. Walton County contends that the Sandestin DRI has no allowances for building and land use ancillary, yet the county granted 83,000, almost 84,000 square feet of building ancillary space to the Grand Boulevard. Based on the DCA definition, both at the time of the submittal and grandfathered in what was already built. And we're asking and thought we had agreement that we would be allowed to do the same. County doesn't include the Finn's Beach Club or Burt Pine Clubhouses in their square feet takedown because they claim them as ancillary since they are private, which we agree. The county granted 57,276 square foot of ancillary use for the conference center located in the villages of Baytown Wharf, Phase 2. And again, for a certain amount for parcels 220 and 320. The county contends that the developer must analyze where Sandestin is today against what was previously approved, regardless of proven past reporting mistakes. Yet they disallowed the approved 2004 development order and want to use the 2002 development order instead because they say 2004 was fraught with errors. The county contends that all past non-residential reporting via categories is restrictive to not only that use, however, in numerous NOPCs since '84, the county has approved and allowed Sandestin the ability to swap around square feet between all categories. Due to this ever-moving target, the developer has simply utilized the intent of the DRI along with the history of the county NOPC approvals and therefore developed a one bucket of non-residential square foot to pull from. Lastly, the county contends that the Sandestin DRI is out of compliance due to the developer misrepresenting non-residential square foot used and or what the entitlements remain per the 2013 annual report. Yet the county states, based on their own calculations again, that there's 151,791 square feet remaining to be built by the developer. However, the developer has not overbuilt, yet the county claims Sandestin is out of compliance due to alleged reporting areas by the developer, when in the fact the developer is trying to correct all these past reporting areas since he bought the property in 2010. Excuse me. In addressing the SOA's concerns, Ms. Gray reports that we should be out of noncompliance. It's computed against what was reported again in the 2002 NOPC. And again, this isn't the latest NOPC that was approved. And DOS stipulated that 2002 NOPC was not to be used in determining compliance. The SOA states that the developer has overbuilt non-residential by 20,540 square foot. This is based on them disallowing all of the ancillary in the residential development that was previously approved by the county at DCA's discretion, at DCA's direction. They also disapprove all building ancillary that's square foot approved by the county for the Grand Boulevard development. In summary, we have been working in cooperation, and I believe in good faith, with the county, only to be subjected to changes in position and or our results. The total area of the development, this is something else that I think is real important. When these parcel maps were created, I thought it was very important. We just couldn't have a spreadsheet that showed it. We had to have these maps. We had to have all the puzzles in the jigsaw puzzle fit. And the way that I knew it was right was when you added up all the parcels today and took the 1984 acreage of what the development was, that was never surveyed. It was just simply probably perimetered, and added and subtracted all of the acreage that was done in every NOPC since '84. There was an 8-acre difference between what we did and the intent of what the map was supposed to be, which is a 0.5% error, which I feel very comfortable that this exercise was a very good success. The county agrees that the developer has residential and non-residential entitlements remaining. The development is less dense than what was approved in '76 and 1985. The development was never found to be in a substantial deviation. I think it's important that you realize that developments of regional impact are based on what's being built out there and the impacts it has on the region. If there's entitlements that are left, forget the acreage calculations. Just look strictly at entitlements. We are way underneath the impacts that were presented and invested since 1976. And you should find us in compliance. Thank you.
Thank you. Any questions on the board? Seeing none, Ms. Stewart.
Mr. Denton, let me just ask you a couple questions. I take it it's your position that the 1976 data controls this
as it relates to my presentation, it's hard. The acreage, it's only a presentation of acreage in 1976, and it's also only a presentation of acreage in the '84 development order.
Didn't you, in fact, write a letter to Ms. Bradley indicating that the 84 was the baseline that everything should be measured from?
I insinuated in the opportunity of trying to cooperate and figure out a baseline that everybody could agree to, that 84 should be considered. Not the 84 agreement, but the 84 development order.
Well, as your insinuation, did you say on August 28, 1984, the Walton County Commission has granted non-substantial determination per Resolution 8424 with the subsequent DO establishing a new threshold of 954.8 acres of recreational / open space? That was the 84 agreement, not the supplemental.
That was similar into trying to figure out open space as it relates to taking all the roadway half. It was an attempt to try and find common ground to move forward.
All right, so in anywhere in this letter, did you indicate that you believe the 76 documents controlled?
No, I did not.
Are you familiar
Because when
with,
we were talking in that document, it was strictly about open space.
okay, and let me ask you if you a letter written by Mr. Matthews or memo to Ms. Craig that basically says intent Sandestin will supply a revised 2011 annual report with all ancillary uses accounted for per building and land use, and then categorically compare them against the 1985 Department of Community Affairs entitlement and acreage categories via separate document.
Mm-hmm.
Are you familiar with that one?
I believe so.
Do you recall if Mr. Matthews referenced at any time the 1976 documents controlling?
I do not know what Mr. Matthews has done since that document was written.
Do you recall if he referenced it in here?
I just read it from what you showed me.
He didn't reference 1976, did he?
No, I'm saying only what he says in that letter. Can I reference what he stated?
Now, are you familiar with Ordinance 89-9, adopted by the Walton County Board of County Commissioners approving a development order amending a finding of non-substantial deviation to the 1976 development of regional impact development orders for the Sandestin DRI?
I'd have to see what you're talking about.
Does that look familiar?
This was an 89 NOPC.
Could you read the highlighted portion in yellow of that ordinance?
On August 28, 1984, the board approved a revised master plan for Sandestin, which became, through agreement and attached hereto as Exhibit A, with the State Department of Community Affairs, the benchmark for review of any additional changes to the Sandestin DRI.
Doesn't that ordinance stand for the proposition that Walton County has now adopted that settlement agreement as the baseline?
As it relates to report categorically, potentially yes, but not necessarily.
Potentially yes?
But not necessarily as it relates to the vested entitlements.
Oh, I see. But in terms of as far as Walton County and how they were going to view Sandestin, weren't they in fact indicating that that agreement as supplemented was going to be what was controlling in terms of the baseline?
As it relates to the category reporting?
Now, you also raised a question about ancillary and cited some language from DCA. What was exactly that document from?
I pulled that from, I'd have to look back, and I believe it's in the exhibits. It was a reference that I received from your files, I believe, from staff as it relates to what would be acceptable ancillary language.
But are you familiar with the? Were you present when Mr. Metcalf reviewed his response from Anna Richmond on ancillary space?
Yes, I see this now.
Could you read that again, that ancillary space?
The definition of ancillary space?
Well,
what, number one?
What Ms. Richmond responded to.
The Department's letter states that the Sandestin DR Development Order does not reference or define the term ancillary space. The lack of a definition in the development order does not preclude the county from amending the development order to define the term and applying it in future development orders.
Isn't that inconsistent with the language you cited for ancillary space?
No, because basically the county did come back and use this language and provide ancillary space.
Okay. Now, finally, in terms of the information you were talking about ground truthing, did you make any effort to go back and see what Interwest had done in terms of this prior ground truthing before you did this most recent endeavor?
I'm not sure I understand the question, but all I could say is that I got involved when Interwest was in the process of ground truthing the development. And again, like I said, all I saw was a summary of spreadsheets of the ground truthing. And I said, we need to be more accountable than that. We need parcel by parcel mapping to put the jigsaw puzzle together so anybody can pick it up. So it's for ease of dissemination and for ease of continuing. Everything that we've been trying to do is trying to create a new development that can be accountable for how they move how they move forward, because it's clear to try and reconcile where we've been is impossible.
And in fact, didn't in 02 and 03 Interwest oversee and do this exact type of ground truthing?
I do not know. I was not involved then.
Thank you, Mr. Denton. I have nothing further.
I've got a couple of questions.
If I could go ahead and admit these, I'd like to admit ordinance 89-9 as our next exhibit. I'd like to introduce Mr. Jansen's letter dated August 9th, 2013, and Mr. Matthews' memo to Ms. Craig dated September 27th, I believe, 2012.
Any objections? No objections, we'll mark the numbers, get them called up.
Remit them into evidence.
Thank you, Mr. Chairman.
Correct. Okay.
Mr. Danton, first document I've showed you, it's already in evidence, is an excerpt from the 1984 settlement agreement. Mr. Stewart is making a big deal about whether or not what the appropriate acreage was in 1984 according to that settlement agreement and what would be applied for future compliance determination or substantial deviation determination. Will you read to the Commission what the settlement agreement says about open space as to what the department was looking for?
It basically says that the 84 master plan approved by Walton County, within all land divided, they would like all the land divided into number-coded parcels together with a description containing approximate and conceptual identification for each development parcel of the following: location and acreage, current ownership, intended land use, number of dwelling units, whether and or the extent to which it is to be left in a natural condition, maximum square footage of commercial or office space, location of known archaeological sites, and number of marina slips, if any.
Go ahead. So it never uses the term open space, does it?
No.
You go back and read the commissioners again. Whether or not what?
Whether or the extent to which it is to be left in a natural condition.
Okay. Doesn't say anything about having a minimum amount of acres in open space or changing the 1974 ADA and the 76 DRI, does it?
No, it does not.
Okay. All right. Go to Mr. Stewart wanted to show you this 1989 DO trying to allege that the county has somehow adopted this settlement agreement. I've handed you the 2002 development order that was issued by this, maybe not this board, but a prior Board of County Commissioners executed by the chairman after proper public notice and hearing and comment with objections. Would you read the findings of fact by this county on that ordinance there? And what's the date of it?
The date of this is November 4th, 2002.
So that's after 1989, correct?
Yes, it is.
Okay. Read it for the commissioners, please.
The Sandestin DRI development order was approved by Walton County in 1976 prior to the time the county adopted its comprehensive plan and land development regulations establishing the concurrency requirements. Therefore, the Sandestin DRI has required vested rights which preclude the application of Walton County Comprehensive Plan and implementing land development regulations to the Sandestin DRI, including the non-substantial deviation changes proposed in this notification.
Doesn't say anything about ratifying some 1984 agreement with DCA, does it?
It does not.
Thank you. No other questions?
Mr. Davis, one other matter, housekeeping matter. We did reference these minutes in Mr. Burgess's testimony. I'd like to go ahead and introduce these two, in particular note item E, which approved a intrusion into the golf course buffer.
Mr. Matthews, do you have any objection?
No.
Mr. Chairman.
Accept it.
Thank you, sir.
Mr. Matthews, you have somebody else to go?
Yes, sir.
Okay, based upon my calculations with the breaks and the rebuttal and what have you, I see approximately 20 minutes add-on.
I thought we had like 27, Mark.
I had calculated to 5 after, and with the next break, it would have been 10 after, so yeah.
All right, so you're saying 20?
Yes, sir. You're
15.
14.
I got, well, let me recount
time
it.
do I
I got
have?
22 minutes, sir.
From here, from right now?
Right now.
All right, you know what I gotta say.
Frankly, I'm amazed we're that close.
Yeah, we're pretty close.
Thank you, Mr. Chairman. I'm going to present some closing, and if they will grab me, I'll try to speak fast and let Mr. Becknell speak for the last couple minutes. You know, I find I've been involved in land use for many, many years, and frankly, I'm stunned. I don't know how we got to where we got that we have to be here today. Y'all, we've had some acrimony, obviously, in the last few months, but we're moving down the right path up until this last summer, and I'll get to that at the end of my talk. But what we're here today is what this board, through Mr. Davis's memo and y'all's vote, is on whether or not a development, Sandestin development, is in compliance. That's what, and then you lose staff's report, and all the witnesses put it up here, 380-06-17, monitoring. It doesn't say anything about development being in compliance, and yet that's the legal basis by which we are here today. What the statute says, and what several people have mentioned to you, I will make sure you all understand, it's whether this developer, Sandestin Investments, is in substantial compliance with the existing development order. Not whether the development order. The legislature could have made it whether a development order, but they don't. There's another statute that deals with that. Mr. Metcalf pointed out to you. That's a separate statute, separate enforcement mechanism that you are entitled to have a hearing on and conduct a hearing to determine whether or not the development is whether there's been a substantial deviation has occurred out there, but that's not what we're here for today. And that is not the statutory basis for what we're here today. And we're here on a false premise. That's the biggest problem, is because we're here on whether a development is in compliance when that's not what the statute says, and that's not, and even staff's own lawyers and your lawyer agree. How did we get here? We got here because back when the DRIs were done in the 70s and even in the 80s, you didn't survey property. We're talking about 2,000 acres. This is what you look at. This was the one from 84. Nobody can find the one in 76, except some reduced down version that's more smudgy than this one. You couldn't read it if you put it in front of you. How do you know how many acres that is right there? How do you know this is all raw land? You heard Mr. Boss. This is all raw land. Somebody, and you heard Mr. Dan, cartoons. I don't know what it is, but the bottom line is people doing the best they can to give you an idea and a conceptual plan. It is not a survey. This developer, under the law, was granted, this developer, SDI, inherited through the process on where we're at today. When he bought this resort on March 15, 2010, going to why we're here today on this compliance, hasn't conducted development activity. Mr. Metcalf went through the definition of development activity on his slides with you. And Ms. Meadows wants to say, oh, well, he pulled a DO. That's not development activity under the statute. Oh, he went and applied for this. He didn't build anything. That's not development activity. You go and some tenant does a remodel at Baytown Wharf that there'd been tenants there before when he bought the resort. That's not development activity by this developer. To hold Mr. Becknell or Sandestin Investments, if under, again, false premise on why we're here, but if you're going to try to convert this into a substantial deviation determination hearing, which I don't think you have the legal right to do, and I think Mark will tell you that, is that you would have to determine that nobody could do anything out there. I know Miss Lenan wouldn't like that. She wants to get carved out. I know Miss Lynch would like to get, Roger Murray carved out, and other general contractors carved out who are building in there. You couldn't do that. But we're here on a compliance whether this developer has conducted development activity. There's been no evidence given to you by any of the witnesses that SDI has done any of this. Now, all this occurred, everything we've heard goes all the way back. We've heard stuff from 1976, I think, Mr. Boss' involvement, all the way up through the current date. But everything that the objectors have put on, including your staff, as to what they think there are issues out there, they're blaming, they want you to have a compliance hearing and shut down and not issue any permits, but not for anything that Mr. Becknell or his company did. They want to talk about what happened back in 1984 or in 1988, 1999, 2000. Let's start with Mr. Heath and his witnesses. I don't know. I don't doubt that it floods out there. I mean, I've seen the pictures, so unless somebody's making them up or something, I don't doubt it. But that ain't got nothing to do with SDI. They didn't create Driftwood Estates. They didn't create some non-compliance issue. This county approved a development order in 2002 through a notice of proposed change at Interwest Request, who was the developer at the time, and subsequently came in and got plats for 413 single-family lots. The county did this. The county and their staff did this. SDI didn't do anything about this. Now, apparently, at least there seems to be some evidence, according to Mr. Heath and his clients, that when they created those subdivisions, they created flooding issues out there. Okay, maybe they did. Again, that's not, my client didn't do that. And frankly, Interwest didn't do it. They sold the property. You know about the lawsuit. Y'all were drug into it. They filed a lawsuit against Olson Associates and North Tip and David Campbell and Walton County and Interwest, and it's been in litigation for 7 years. Interesting, Interwest was released. They were dismissed out of the case because they settled with Greater Driftwood. Walton County didn't get joined in the last amended complaint that was filed. Why is that? They're complaining today, their witnesses, about all this issue, about drainage and everything else, and pointing at the county for doing all these approvals, yet you're no longer a defendant in their case. Wonder why? If they got an issue, I don't know who's responsible for maintaining the stormwater system out there today. If the HOA assumed that responsibility, if the county has that responsibility, I don't know. It's one of the two. I know because I do dirt work, but it ain't SDI. And SDI can't be complained about to be held in non-compliance for something that happened 12 years ago. I want to talk, as you know, and I know it's been mentioned, but again, and we put this into evidence. We didn't have enough time today, and I know that y'all aren't going to read 5,000 pages worth of documents. That would be impossible for you to do. But that's what you got in evidence before you, between all these different lawyers and the different parties. We've got 2 notebooks, and one of the things, if you do go back to look at evidence, that I find interesting when staff filed their report, and then they sent us to an FTP site where they uploaded documents that they were going to be their exhibits. They started in '84. Nothing before that. They didn't have the 1974 ADA. They didn't have the 1976 DRI. They didn't have the first NOPC and non-substantial determination order by this board in 1980. They didn't have any of the NOPCs that were done in 84, 89, 90, I can go on and on. There's 9 of them. They didn't have any of that in their evidence. The reason why they didn't, because it doesn't support their position. And that's why I put it into evidence, because the only way that that this developer, SDI, or any of the prior developers could lose the rights that they got in the 76 DRI through the 74 ADA would be for this commission to make a finding of a substantial deviation. That's never happened. Make sure y'all understand, there is no building going on today by this developer to trigger any kind of a compliance or deviation. Again, I think that Ken Metcalf probably put it best. Staff's premature. Now, how do we get premature? We get premature, and I know Ms. Meadows mentioned in her cross-examination or her comments about, let me find that. Said we got a DO for Osprey Point. That's not development activity under the statute. Put some blow-up thing in the bay. She's talking about a kid's, jumpy little thing. That's not development activity in the DRI. And in fact, the bay is not within the DRI. That's submerged land lease and deals with the DEP. Tore a building down and dumped it into the bay. She's talking about the new welcome center that was approved in the front entrance into the resort that the county gave a development order and building permit on, and is not within the DRI, Ms. Meadows. It's in the vested area, and it has nothing to do with this hearing because the vested area is not part of a compliance in the DRI. And submitted for a Ferris wheel. Well, y'all turned that down, so that's not up there, so you can't use that for a compliance issue or development activity. So the okay, thank you very much for pointing that out. The open space that was approved. Let's talk about what the open space was in 74, because I know you've gotten all these numbers. But what was the vested was the 604 acres, and Mr. Burgess told you that if you added the road and a power line, it took it up to like 709. Obviously, according to our calculations, or even staff's calculations, there's a heck of a lot. It's either staff's, there's 980 or 10,023 or 1,183 that report. There's more than 709 out there, and that's what is only thing that is required and vested. And why is that important? Because what the DCA does, when you go through a year and a half DRI approval process, the purpose of it is, one of the reasons is to evaluate the regional impacts outside the external boundaries of the DRI itself. So how would traffic be impacted on, of course, old 98 back then, a little two-lane road, but how would traffic be handled? How would stormwater be handled? How would educational facilities impact, archaeological, all the different things that we normally go through a major development order process on a smaller project. Now you're doing it on 2,000 acres. So when they set the benchmark at the 709, if you include roads of acreage, you know that on 2,000 acres, that is 14, 20, I mean, that's less than 20, that's around 25% would make it 2,800, so it's less than 25%. The developer records today show that they got like 47, 48% of the resort in open space. That doesn't mean they have to keep that in open space. That's just what it is. I mean, Mr. Boss described to you the purpose of having an integral cell. It's called a cell development of mixed use of a community. You don't just have big old pods of property everywhere. You create it as you go along for the ambiance, as it was read to you, and the whole integration of this mixed-use facility out there. So our bottom line, the position is that we have not exceeded any open space requirements under the 76. And even if you determined that we're supposed to have 954 according to Greg Stewart, that doesn't mean we're out of compliance. It doesn't mean we're out of compliance. You can say, we want you to go file an NOPC. But let's and then I want to shift to that real quick, because there's been a lot made about, well, because this is staff's report. Well, you need to file an NOPC for ancillary. You need to file an NOPC on open space. You need to file an NOPC to show what happened to this 128.1 acres that we can't find, but Mr. Heath was able to find today, and Dean Birch has explained to you exactly how it came about. But you got to go file an NOPC. Okay, that has nothing to do with finding a development out of compliance. This, and I'm going to start with ancillary. I really get offended when things get misrepresented or get slanted a different way to this board. One of my exhibits, 35 in one of these books, 35, exhibit 35 through 44, I think, is a series of development orders and permits and correspondence between the Howard Group and this staff, which was actually Pat Blackshear and Lois at the time, but Renee was involved because she's on some of those emails. Linda Clark was involved. Linda Clark got a letter from the DCA, which is in those exhibits, that says you can use this definition of ancillary. even though a new DEO person 3 days ago, or whenever that letter is that Mr. Greg Stewart put in, now has a different opinion. But DCA had a different opinion back when Keith Howard was trying to get ancillary approved by this county, and the county approved it. 83,000 square foot worth of Grand Boulevard. And I'm not criticizing him, because he's right. The whole conference center at Baytown Wharf was determined to be ancillary. 53,000 square foot. You know why? Because it doesn't create additional regional impacts external to the resort. The people are already there. People are already there using it. So that's why the county went to wanting updated traffic studies anytime they did any of this. Anyway, apparently my time is out. I don't have any. I'm going to. All right. The staff report, and again, I'm a little offended the way it gets skewed to you from presentation by staff today and by Ms. Gray on the commercial element. Let's talk about this non-residential. We have, by staff's own admission, 117,000, I think it is, square foot of commercial entitlement left to be built. There's no dispute about that. We haven't built it. And that's still there. What they're complaining about is they don't like what we reported in the annual report. They don't like the fact that we've tried to take some additional square footage and put it back in, which is ancillary under the county and the Grand Boulevard definition and the DCA definition at the time. That's what they don't like. But if finding an annual report, you got a disagreement. If you all say, well, we don't like your annual report either. We like staff's opinion of your annual report. That's not grounds to find somebody in compliance and quit issuing permits. And say, if y'all don't agree on a methodology, go litigate that issue. All you got to do, because really what we would like from y'all is say, staff, you've heard all the presentation here today. Staff, we agree that this developer has not, that this county in no prior NOPCs have ever changed the vested rights in the 1976 DRI. If you say that and you say that is the baseline by which you will look at open space, commercial, non-residential, and you tell them that, you say you look at that and then you look at the subsequent NOPCs and give them that direction, we'll get this all resolved. And there will be another NOPC, but it'll come in. The reason why everything is falling apart is because we have a diametrically opposed opinion as to what the governing documents apply. They want to stick us with a non-substantial deviation settlement agreement that Boss Corporation entered into in 1984 with the DCA that y'all weren't parties to and no subsequent developer is required to comply with. So if we get that issue resolved and if we disagree, I mean, that's a simple issue to go litigate if y'all don't agree. But if y'all agree and we presented that, and your staff has presented nothing to the contrary, and they have the burden of proof here today through a preponderance of the evidence, all you got to do is say the developer is vested in 76. None of our county commission meetings ever changed any of that. Y'all go back to the drawing board and get us an annual report with your methodology, and we could do that. And we would be able to be back here on NOPC that everybody would agree to. The problem is we don't have an agreement on methodology. Finally, if you, although I appreciate Nancy, she's smart, Lenan, and Lisa Minshew, you can't carve out other developers. If you're determining that a quote-unquote resort, as Mr. Davis couched it in terms of why we're here today, is out of compliance, then you can't issue permits to anybody, whether it be a general contractor, a homeowner who wants to build a home, somebody wants to build a shed, the Hilton finishing up their project, Grand Boulevard who needs to get their stuff. I'm not suggesting you do that because I think that's wrong. But I think it's also wrong that you would, if you allow them to go forward, you can't turn around and treat us or Sandestin any differently. Anyway, that's all I got. Thank you very much.
Thank you.
Mr. Matthews, is that?
2 minutes?
About 2 minutes. I have 2 minutes.
I guess he's done.
I have 2 minutes.
Looking at that clock. Don't know that I can do much in 2 minutes.
Just state your name for the record, sir.
Tom Becknell, Sandestin. I'll be very brief. When the family acquired Sandestin in 2010, I held a public meeting and all the owners of Sandestin were invited. We had about 300 people show up. I think a couple of you commissioners were actually there as well. I told them a couple of things about my vision for Sandestin. 3 of them are important. 1, I wanted to bring it back into being a family resort, family-oriented. 2, I would never surprise them with what I was doing. I would tell them in advance what our plans were. And 3, we would make an effort to find out what is being what is here and what is left. I've done that. The complaint by the SOA about the arcade, the zip line, the ropes course, the carousel for kids is absurd. You can't shut down the nightclubs and not have something to bring the families there, or you would have a dark resort. We have turned the tide on that attitude, and now we are a family resort. I have Ground Truth Resort. I won't go into that. You've seen it. Every parcel in Sandestin has been surveyed and everything on it identified. And I have never held back on what our plans were with the SOA. Unfortunately, my communication has been one-sided. I give them information. They use it in an effort to try to stop whatever we're doing. It's the NIMBY attitude, not in my backyard. However, I will tell you that those people that are here and those members of the board that advocate that do not represent the 4,000 owners in Sandestin. There are a number of people who disagree with their position. And I will close by saying this. Mrs. Meadows, I'm terribly disappointed that you think I and all of the other 4,000 members of Sandestin bought a pig.
All right.
Mr. Chairman, the next scheduled presenter would be the... Sure.
We're going to take a 5-minute break. We'll be back. Come to order, please. Come to order. Mr. Davis.
I believe we are to the point of staff's rebuttal. Is that correct?
Yes, we'll rest on our prior presented case.
Okay, thank you.
Thank you. Commissioners, the next step, according to the adopted procedure, is for you to have a motion and a second whether or not to find the development in substantial compliance with the DRI or not. You can do that today and direct staff to prepare the appropriate, staff and me, to prepare the appropriate findings of fact and conclusions of law to be voted on at the next meeting. Or you can not make that determination today and ask the various parties to submit proposed findings of fact and conclusions of law, and we would then recommend an order to you at the next meeting. The procedure we adopted was that you would go ahead and vote today on a compliance finding or not, and then direct the staff and me to prepare such an order. And Mr. Stewart, I assume you have no objections to the staff preparing that order, whichever way. Okay. So it is your pleasure which way you'd like to go at this point.
It's the board's wishes.
Now, I understand you've received a lot of information today, so either way is fine. Legally, either way is fine on me.
Ms. Meadows? For the record, the chair has passed the gavel to the vice chair. Agreeing with council, we have heard right about 8 or 9 hours of testimony today. There's a lot here. Each side's got their own specific reasons why we should roll in one favor or the other. And I would personally like to have the opportunity to read the final, have each council send a brief, if that's the right term, to us, so we have the opportunity to read all that, because I can tell you I can't remember everything that was talked about at 9 o'clock this morning. So my motion is that we allow each party to submit a brief to the respective commissions for our opportunity to review it and then address it at our June 24th board meeting.
And can I make, I'm sorry, go ahead. You need a second on the motion, I'm sorry.
Okay, that's my motion.
I will second for discussion.
Okay.
In terms of clarification, I think what would be, if assuming you vote on this motion, what would be appropriate would be proposed orders that have findings of fact and conclusions of law that would be submitted to the staff and to me, and then we would have you copied on them, and then we will recommend one to you at the June 24th.
Well,
meeting.
one of the things is, you set out a procedure for us to follow, and we have followed it.
Harshly.
So now, are we going to vary from it? And I think that's the question. I mean, we've made everybody else follow what you set out, and now we've come up with another scenario. It's just, this could go on and on and on for years. I think we ought to just figure out what we're going to do. You will never be more clear on the testimony than you are today. I mean, we've sat here and you've heard it firsthand. You will never be more clear. You will have to regurgitate this and there will be a lot of time passed between the time now that you vote again. So, in my opinion, we should go ahead and discuss the compliance, non-compliance issue, and we should make a vote. We should vote today.
Well, let me add a comment. From what I can hear out here, staff has their method of calculating whatever. Sandestin has their method of calculating these different categories. And it's unfortunate that we can't get the two parties together to come up with an agreed methodology to calculate all these things and create and clear this thing up with one NOPC.
Well, it's been going on for 3 or 4 years, and I can, and I've been in some of the meetings and such. The developer's always going to, push the envelope one way, and the county codes and the regulations are set in place, and it's just by nature of what they do is that they're going to push for the most units, the most that they can get. I mean, that's pretty natural. And our staff has been working on this for, I don't know how many years, how many hours. This is costing the taxpayers a lot of money. So I think we need to, not kick the can down the road anymore. Make a decision, move on. Either way we decide, there's going to be people that are not happy with the decision. And any way we decide, there's going to always be challenges. So it just depends on which side you want to be challenged from, is my take on that. Now, I'm a certified planner. I have worked for private industry, private engineers, developers. I've prepared and submitted and reviewed and gone through the DRI process. So based on my experience with them is that what staff is telling us is correct.
We probably need to take a vote on the procedure first, and then we'll get to the discussion, assuming how the vote goes on the compliance.
I think you want to say something first.
Yeah, I think staff position is going to be what it is.
Yeah.
Unless the developer's willing to, concede to what staff position is.
Right.
There's no use. I mean, you can't.
The staff can't keep going, throw that in.
Mm-hmm.
Throw that in. Yeah, we can count let's count the roads as open space. Yeah, let's count,
Yeah.
I mean, we've made concessions out, I think, a lot of concessions. And I think that when you buy a property, the entitlements run with the land. And this particular land had a lot of history and a lot of entitlements and a lot of things that were and as staff said, there wasn't anything that the developer didn't know when he purchased this property that were going to be a problem. And I think the comment was, I'll handle that. So, that I think this does send a message today as to how we're going to proceed with this county. Are people going to be? Are they going to be able to rely on what our code says and what we do and what we say, or not? And if not, then I don't think we can invite people here to spend hundreds of thousands of dollars on homes and places and live here if we're not going to keep our end of the bargain.
Well,
Ms. Meadows, I just want to remind you, you're the chairman at this point, so the chairman has passed the gavel. I just wanted to...
Oh, yeah, I forgot. Okay. Okay.
And I don't know exactly how to put this. I think there's enough blame to go around in this room for everybody, and this goes back when you talk about this commission did this. I was raising babies in 1976, running a funeral home. So, this goes back further than any of us sitting here today. I have always said that I have to rely on staff. All of us up here have to rely on what staff says, and I have to rely on my attorney, who is representing this board, to give me guidance.
So shall we call the question on this particular vote?
Yeah, and this vote is whether or not to allow a submission of proposed changes.
Right.
Versus voting.
You mean? Oh,
yeah,
in other
that
words, put it
that
off
was
for 2 weeks.
Right.
Yeah.
Okay.
You're the chair.
Yeah. So do I? Okay. There's a motion and a second. Okay. All in favor of the motion, say aye.
Aye.
All opposed to the motion, say aye. Aye.
I'm opposed.
Okay. Okay. The motion fails 3-1.
Okay. So that the next
There you go.
next motion should be whether or not to find compliance or non-compliance per the memo.
Would you say that again?
The next motion should be then whether to find compliance or non-compliance per the memorandum.
Well, based on what I've heard today and the testimony given, I would make a motion that the DRI is not in compliance, and that any further development would require an NOPC.
That's for you going to draft the language. Is that what we're talking about now?
Yes. Well, we'll have
And
to have
he'll
an
draft the
order.
language.
You're going to draft the language to be approved at the 24th meeting?
Yes.
Second.
Okay, we got a motion and a second. All in favor say aye.
Aye.
Opposed? Motion carries. There's no further